Hello, my friends. Thank you so much for coming to spend part of your Monday, November 27th with me. And welcome to the world, or the post-apocalyptic world of post-trial civil motions, which happen in every case. But in a case like Maya's that everyone is so emotionally invested in, they seem to take on a whole new meaning, huh? So, what I had intended to do today, was to go over the motion that was filed on Friday by the defense. It's their new motion for a new trial and to reduce the verdict and to throw out the verdict and to please give us another chance. And we didn't do it, but if we did it, it wasn't really so bad. And even if we did do it, it wasn't worth what the jury awarded, even though we don't think the jury made the right decision and we don't think there was any evidence to justify the awards that the jury made. And we want you to throw them all out. Even if all of that happened, then, please just give us a new trial and or reduce the verdict and or, just overturn the verdict altogether, Judge, before we go file our appeal, because we're going to go file our appeal no matter what. And we don't want to do that yet because first we know we have to come to you, Judge Carroll, and we have to have you deny this motion before we can go to the appellate court. So what I was going to do, and I have it prepared, and there's 144 pages of it, and we can go over it a little bit more briefly. That's the NARC prayer. I didn't do it, but if I did it, it wasn't that bad. And I didn't do it, but you imagined it. And even if I did do it, you're overreacting, right? I see what you're doing there, Skoda. I'm picking up what you're laying down. Hello, Cali girl. Yes, this stuff is insane, insane, insane. Yes. So we can do that. And I have that motion pulled up. It's 144 pages. And of course, I intended to read all 144 pages today. And then, life happened. Kids had to be driven to places and et cetera, ad nauseum. But what I just found in the court file that was filed today is some additional information that the defense thought it would be really important to tell the court about juror number 1. So I don't know if any of you have seen that yet, and that might be the first exciting thing to happen today. So what I'd like to do is first give you the supplemental defense response that they filed today around noon or 12:30. More dirt that they've dug up on juror number 1, as if what they did already to juror number 1 wasn't bad enough. Now they've got to throw some more logs on the fire as such. Thank you, Laura Kang, for your super sticker, getting right in there. I appreciate you so much. So let's take a look at that first, because it's very quick. It's 5 pages. And then, of course, the plaintiff responded. Yes, Sarah, I do know that the plaintiff has responded. That's another 144 pages that I haven't read yet, but, we can certainly go over that too. I hate to do it cold because I don't want to dox anyone. Not that I have any trouble with improv or, giving you my opinions on the fly, because this show is 100% improv. I don't script anything. I don't even have any notes tonight at all. I have what I highlighted on that document, and I already know what my thoughts are. So this doesn't take a whole lot of scripting from me. So I'm perfectly willing to do that. But yeah, let's look at what they filed today, the defense, the additional information on juror number 1. It's a supplemental response. It's a supplement to to defense motion for a new trial regarding juror number 1. And it's like, here, Judge, we dug up some more dirt on juror number 1, as if what we gave you last week on the Thanksgiving weekend wasn't enough for you. We have some more information for you that may help you come to our conclusion, because, of course, that's what we want you to do. And listen, you guys, this is not, people seem to be freaking out about this, but it is not in any way, shape, or form unusual for this to be going on right now. This is exactly what happens after every jury verdict. There is nothing at all unusual about this. You may not like the language, you may not like their position, but this is something that is summarily done in every single jury verdict, unless, in the rare case, that the jury comes back in an amount that is less than what the plaintiff wanted to settle the case, then of course these motions would not be made. The case would just be settled for a lesser amount, and we would not be here talking about this post-trial apocalypse of motions. But let me tell you that in my world, and this is something that I do every day, this is very, very common. Okay, so don't freak out about it. It's always done, and it's not out of the ordinary. Some of the stuff that they've said, I think, is a little bit beyond the pale, but look, it's not my style, and it's not the way that I might handle this, but, you know, it's not my case. Let me just see one thing. Hold on one second. All right, I realize that there are other people that are live now too, which is cool. And if you want to go watch those other people, that's totally cool. Go do that. But to put that in the chat is kind of redirecting people to other streams. And look, when I put this up early this morning, I checked to see if anybody else was doing this at the same time. They're not. So they weren't, at least when I put this up. So if you would like to go watch someone else, that's great. But try and refrain from taking other people with you who might want to stay here, or at least like kind of disrupting the chat. And I would not expect you ever to go into someone else's chat when I was live and tell people to come over here. So it's just not cool. There's room for everybody. People can watch it on replay. Whatevs, not a big whoop. All right. Okay, so here is the supplement to defendant's motion for a new trial based on juror misconduct, motion for juror interview, motion to open emergency discovery evidence, and an emergency motion to preserve the evidence. Okay, so this is in addition to the motion that defense filed last week about juror number 1. Here's what they're saying. Judge, we have new evidence. Let me just go back to this so it's on. And here's the supplemental background that we found from, you know, maybe some anonymous sources. I have not read this yet, so we're doing this one cold, you guys. Since filing the above referenced motion, defendant has discovered additional material evidence of potential juror bias and misconduct as set forth herein. Specifically, defendant has discovered from the website of the Clerk of Courts of Broward County, Florida, that juror number 1 was the respondent in a domestic violence case. They give the case number, the state reporting number, and it was filed in July of 2002. July of 2002. So 20 years ago, they're saying juror number 1 was involved. He was a respondent in a domestic violence case against him by a former spouse that involved a, quote, sworn notice of allegations of child abuse in Exhibit A. The content of the underlying filings are not available for defendant to review. That's right, because they're private and they're sealed. However, given the allegations of child abuse, it's reasonable to assume that the Department of Children and Families, or DCF, a key player in the present case, may have been involved in the domestic violence proceeding. Defendant submits that juror number 1 should have disclosed this information on the supplemental jury questionnaire, which I actually have, and we can take a look at if you like, during voir dire or during trial when his potential bias was called into question by evidence presented in the case. Without regard to his innocence or guilt, it is reasonable to assume that juror number 1 may have harbored ill feelings towards the DCF, or at a minimum an allegiance in favor of a party accused of suspected child abuse, like the late Beata Kowalski. Under the circumstances, the existence of this information and juror number 1's failure to disclose it corroborates defendant's reasonable belief that juror number 1 was inherently biased against DCF and defendant and harbored an allegiance with Mrs. Kowalski and plaintiffs, resulting in a verdict motivated by emotion and extra record evidence rather than an objective evaluation of the facts. Moreover, juror number 1 suspected hostility toward defendant and defense counsel and bias in plaintiff's favor has been further corroborated by his continued post-verdict social media posts. Okay, so now they're going after what he's saying post-verdict. When we went over this last week, the judge said it was okay for him to talk. But the defense is still maybe surveilling him, stalking him, whatever word you want to use. Most recently, on November 23rd, 2023, juror number 1 posted a statement on the pro-plaintiff Facebook group, Take Care of Maya, named after the sensationalized documentary strategically released on the heels of trial juror number 1's claimed unfamiliarity within his juror questionnaire. In direct opposition to defendant's motion for new trial based on juror misconduct, etc. See Exhibit B. Okay, we'll go to Exhibit B in a moment. In his post, juror number 1 referred to his perceived legal and constitutional freedom of speech and service as a juror without restraint, inappropriately accusing defense counsel Howard Hunter of tyranny and of being, quote, immoral, end quote. Juror number 1 went on to say that he will not coward when challenged by evil, meaning he will not concede his involvement in the impropriety evidenced by facts discovered by the defense post-trial. The internet community is reading juror number 1's post, which are contributing to an eroding confidence in the jury system and the verdict in this case. Okay, I'm going to submit to you, wait, I'm stopping to read for a second, that what is eroding confidence in the jury system among the whole internet community, the whole world wide web of internet community viewers that have viewed this trial, what is eroding confidence in the jury system and or jury duty is the fact that a juror who can volunteer at least 9 weeks of his life to sit on a jury and deliberate on a case can be openly outed by the defense firm and forced to perhaps retain counsel at his own expense and maybe even get in trouble or have to just deal with the agita and the nightmare of what is now going on post-verdict. That is eroding confidence in the jury system. And that's my opinion. And you don't have to like it. You know why? Because I'm not a cupcake. Can't make everyone happy. You're not a cupcake. That's what it says over here on that pink sign that you can't read. That's my opinion. And look, on some other documents that we're going to read, I'm going to have a different opinion. So you can accuse me of having bias, being only one-sided. That's fine. I welcome respectful debate. I really do. But I think what the defense did to juror number 1 post-verdict by putting his name and address out there and his wife's name and address out there in a public forum and documents that they knew would be public, that any one of you can find in the court website without even paying 10 cents. Because when I go into the Utah system, I think I have to pay 20 cents every time I search something. Especially when the defense was so careful to file things under seal that made the hospital look bad. The affidavit of Angela Green, who was their witness with regard to the IJ and the CMS reports, and the attachments to that motion, all of that stuff was filed under seal with the court. But when they chose to out juror number 1 and his wife, that wasn't filed under seal. And I think that is in very poor form. We'll see if there'll be any sanctions for that. I don't know Florida law. I'm not going to pretend to know Florida law. I am a New York State attorney. I have at least 30 years experience in New York State trial courts and federal courts. And we do not allow jurors to ask questions in New York. So this is a big difference between New York and Florida. And I think we're going to find that the fact that the jurors are allowed to ask questions could sometimes lead to problems. And this is one of the problems that I see. In addition to the fact that when the jurors were allowed to ask questions, their identity was not protected as to which juror was asking which question. Therefore, gave the defense a lot of things to complain about. When, by the way, I digress for a moment, they had every opportunity to exclude this juror during voir dire. If he was juror number 1, and he was actually juror number 1, and he said in one of his posts that he was the first guy to check in on the first day of jury duty, he was the first person there, and he was the last person to leave. If he was the first juror there, and I don't know how many jurors they called in for this, but I'm going to assume it was hundreds, if not 1,000 or more, that they had every opportunity to get rid of him. Perhaps they thought that because he was former law enforcement, that he would lean towards their side because they had law enforcement witnesses, detectives. So perhaps that's what they thought. But when it didn't work out in their favor, sour grapes, right? Okay, we go back to the document now, and I'm sorry that I digress. Juror number one's Okay, wait. Well, let me just start from that page again. The internet community is reading juror number one's posts, which are contributing to an eroding confidence in the jury system and the verdict in this case. In addition to the obvious hostility toward defendant and its attorneys on the part of juror number one and his wife, and their bias in plaintiff's favor revealed by the posts, the internet community is now even accusing the court of sharing in that bias. So wait a second. The internet community that's on the hospital side is accusing the judge of being biased now? So they're saying, okay, judge, this is affecting you too and your reputation. Therefore, you have even more reason to grant our motion because you don't want the whole internet community to think that you were biased. Juror number one's statements, as well as numerous other comments he has made surrounding the content of the motion for the new trial based on juror misconduct, etc., reinforces defendant's belief that juror number one was and continues to be biased against the defendant. The statements also suggest that if interviewed, juror number one will respond with a self-serving denial of any bias or misconduct. But his posts reveal a fundamental failure to appreciate that juror misconduct warranting a new trial arises even when there is an appearance of impropriety, as has occurred and continues to occur in this case. As noted in the motion, no amount of indignation and denial of misconduct on the part of juror number one can erase the image of impropriety his words and actions and those of his wife have created and continue to create. Okay, I'm going to now stop reading for one moment to tell you my thoughts on something else. The appearance of impropriety is something that brings me back to the ethics portion of the bar exam. In New York and many other states, not only do you have to take what used to be, I don't know, a 2-day bar exam, but you also have to take an entire ethics test. And in the code of ethics, or the code of professional responsibility that all lawyers are sworn to uphold, you have to avoid, as an attorney or a judge, the appearance of impropriety. And that is a term that is typically applied to lawyers and judges. Never seen it referred to a juror before, and I don't know for a fact whether or not that is something that a juror is sworn to uphold. If anybody in the chat is a practicing attorney in Florida, perhaps you can chime in on that. Yes, Dominique, it seems they really have it out for juror number one. They absolutely 100% do. They do. We didn't do anything wrong, but because juror number one did something wrong, but even if we did do something wrong, it wasn't our fault. And if it was our fault, well, you shouldn't have let it into evidence anyway, judge. And besides which, the verdict is unsustainable. The numbers are too big and you should reduce them. And if you don't reduce them, you should just overturn it and give us a whole new trial. Okay. That's what they're saying. So back to the document. Defendant suspects that juror number one's posts and inappropriate behavior creating a mistrust in the judicial process will continue, and that additional evidence explaining the source of his bias against defendant and in favor of plaintiffs will continue. Defendant therefore reserves the right to supplement its motion with such additional evidence as it comes to light. Signed by C. Howard Hunter. Mr. Hunter. Okay, just take a poll. I can't put a poll in the chat right now because I have too many screens open and I just can't get there. But do you suspect that juror number one's posts after the verdict, if you have seen them, are creating a mistrust in the judicial process? Do you think that? If you think that, put a Y in the chat. If you don't think that, put an N in the chat. And if you don't think that, let me know if you think that there's anything else that's creating a mistrust in the judicial process arising out of this trial. What say you, my friends? What say you? I'm going to pull up the exhibits because we definitely need to take a look at those. SCOTUS says no, but the defense makes me never want to be a juror. I think you're not the only one. Hello, Jennifer. Jennifer says the J-Hatch attorneys are creating a mistrust. Lori says defense juror intimidation. That's what it sounds like to me. Hi, beach lover. So nice to see you today. Nope, they just don't get it. I think I did something to my camera over here. Give me a second. Focus. Sassy living. The defense's attack on the juror and the jury as a whole, as they keep alluding to the jury being too dumb to figure things out. I will agree. Hi, Squids. It's very sad that they want to put that poor girl through the entire thing all over again. I'd love to know what the board of said hospital make. Oh, hundreds of thousands of dollars. It's probably public information. You can probably get that information. Crow Red Eye says casting doubt on a jury they help select makes them look bad. Yeah, it makes them look like, sour grapes. Oh, we thought he was going to be on our side, but then when we found out that he just wasn't, we did everything we could to get him kicked off the trial. And when that didn't work, we're going to keep going. We're just going to keep going. Notice how they did not name him in that response. They did not put his name out there again. Maybe they realized that that was in very poor taste and could have some penalties attached to it. I'm not pretending to know, but it's shocking to me as an attorney. I think that is the appearance of impropriety altogether. As an attorney, you are sworn to avoid the appearance of impropriety, and isn't that improper when you put a juror's name and address out there and his wife's name and address out there for the entire internet community to see? Not just the entire internet community, but anybody who ever wants to go on that court website. Mara says, also, isn't it uncommon for jurors to speak out? Isn't it common? Yes, for jurors to speak out after verdicts, especially in big cases. That's true. I was actually surprised that none did any big media interviews since they were asked for sure. Right, like the Murdoch trial. Remember, after Murdoch, if you believe some of the stuff in that motion, Becky Hill gave everyone a card of some media outlet, and they all flew to New York and they went on Good Morning America or the Today Show or something like that. And they're allowed to do that. They're allowed to do that. Rotorfib says, after watching this trial, I'm kind of sad I live in New York and wouldn't be able to ask questions. I know, but look, there's pros and cons to that. In New York, as an attorney, you are expected to get your evidence out there that you want out there and ask the right questions and prove your case. I think in this case, we saw what can happen, and we saw that the jury was asking a lot of questions that we wanted to know the answers to. So they were playing like cleanup, but it can also lead to problems. And the biggest problem that I see from this case, from allowing the jurors to ask questions, is that they knew which questions juror number one was asking so that they could create this whole entire argument that he was biased from jump. Agree. Callie girl, why does defense need to come at Jules? Right. Courtrooms are open to the public for a reason. You can go and you can sit there all day long if you like and watch any trial that you want to watch. That's our system. It's open to the public, except in certain limited circumstances, like some juvenile court proceedings are not open to the public for obvious reasons. Some family court proceedings are not open to the public for obvious reasons. But she's allowed to be there. She's allowed to be there, and she's allowed to talk about her observations. And interestingly enough, I saw Jules in another chat today when I was watching some coverage earlier, and she said that when she was speaking to juror number one's wife, she did not know that was juror number one's wife. She did not know that. And she also said that not only did she not know who that was, also, that was the other thing, is that when Hippo Lover, which they're saying is the YouTube name of juror number one's wife, was in chats and streams and commenting in Facebook groups, she never said, my husband's on the jury. If you guys have any information to the contrary, tell me. Mujer Barroca, these attorneys are the problem, not the jurors. Yeah, that's the way it looks to me. But look, people say that I'm biased. Yeah, was that where it was? That's perhaps where it was, right? Susan, imagine that this hospital made themselves look even more horrifying. The hospital will be even more. Thank you, Gothic Brina. Yes, can you all please hit the like button? It's free. Just, show a little love. Show a little love. I speak life. I never witnessed the wife say who she was ever in any chat. That is correct. Beautiful, messy ball. They wouldn't go after Chanley Painter, and she does the same thing in national TV and Twitter. Why is YouTube different? Well, isn't Chanley Painter like a reporter for Court TV? Isn't she employed by Court TV, or is she just a court watcher that I thought she was on their staff? I thought she was a staff. I thought she was a paid reporter for Court TV. Skoda says, I spoke to Hippo Lover in a chat. She never identified herself and was totally normal. Nothing stands out about our conversation. Okay, well, let's see what their exhibits look like. Here is their one-page filing that they say evidences that this juror was involved in some sort of a domestic DV claim. I mean, this heading, this Broward County, Florida, domestic violence and child abuse claims made against juror number one, that's their heading. All this is a case search where he's named as the respondent. It says domestic violence. We have no idea what this is about. It says here something was filed called a sworn notice of allegations of child abuse in July 22nd of 2002. Doesn't say if he signed it. There's really no information here, except his name appears in this court record that we know nothing about. That's the first part. That's the first exhibit in their motion. Let's go do the second exhibit, which is the post in Take Care of Maya group, which they have named the pro-plaintiff group. Take Care of Maya. And I will read it to you for those of you who are listening. This was filed today, 11:54 a.m. 11/23/23, juror number one's continued activity in Facebook group Take Care of Maya, as if, he's not allowed to continue now talking, even though the verdict has been rendered since verdict was rendered on November 9th, right, guys? And here's what he wrote in this group. And notice how they redacted the name of the person that he's talking about, but they don't redact his name. But I'm pretty sure, if anybody knows for sure, put it in the chat if you saw this post in the Take Care of Maya group on Facebook, whose name he mentions at the top of this post. Is it Hunter? Is it Shapiro? Is it the defense firm? Is it the hospital? But they redacted that. So, redacted. What you have accused me of occurred after Judge C released all jurors from their oath and duties. I will not have my legal and constitutional freedoms limited by the tyranny of an immoral person such as Hunter or the client that he works for, Johns Hopkins All Children's Hospital. The statement you made is, in my mind, that of a tyrant. Quote, interacting and paying a pro-plaintiff form. Appears you agree with limitations on free speech. You mentioned, quote, optics, end quote. Optics is a word used by people that know no facts and use other people's biased opinions to formulate their own uneducated opinions. I strive to high morals, respecting others, questioning everything, everyone's words and intentions for my safety and that of others. Always have, always will. My mother, father, family, and faith in God have made me what I am today, a law-abiding, good-willed American citizen that will not coward when challenged by evil. I don't know what they think that was meant to prove. I don't think that really bolsters their case, and unless they're trying to say that juror number 1 should be silenced and should not be allowed to speak out still. He continues to speak out, they say. He continues to speak out. Let's go to everyone say hi to the defense in case they're watching. Hi. Hey, what's up, Hunter? What's up, Shapiro? Thanks for not dragging me into your emotion. But, I'm just a small channel. I'm just a young, small channel out here just, trying to entertain some people. Give them a little side of the law sometimes every now and again. Hey, Callie girl. Hi, Reddit. Hi, Reddit. Hello, CC. The trial was public. The jurors didn't receive different information than we did. Nope. Hi, Scott. How are you? The defense is running a play called Hail Mary. Hi, Janelle. Defense is their own worst enemy. Crow Red Eye says juror number 1 sounds like a strong-minded individual. Mara says, as he should. He's free to give his 2 cents about this, especially as it directly involves him and his wife. 100%. I agree. Oh, Donna Marie, did I make you laugh? Oh, Skoda, did I make you laugh? Oh, good. If I can make one person laugh during this stream, makes me very happy. Spetty Ross continues to speak out as if he has a right to. How dare he? How dare you, Paul? How dare you? It's a joke. That's a joke. Hi, Deb Galloway. Not yet anyways. You may know if they do watch. I'm not saying anything improper. I'm just reading the court documents and giving my commentary of it, which is completely within my First Amendment rights, as far as I'm concerned. I was not involved in the trial. I did not have a spouse sitting on the jury, and no one I know is sitting on the jury, but I'm allowed to say what I think is right and not right under the law. Hi, Legalese. It seems they attacked the YouTubers that were trying to stay unbiased. Well, I think they attacked the YouTubers that are the biggest, who have the biggest following, right? If you have a couple 100,000 subs and your videos are getting 100,000 views, they're going to go after the big fish first. They don't care about me right now. So you know what? Keep hitting that subscribe button so that I can keep talking. And so maybe someday I actually will make a difference and somebody will actually listen to me and care what I have to say. Hi, Dominique. Now you're bigger. They're probably watching Melanie, at least some of the Redditors anyway. Oh no, I don't want to be in Reddit. I love Reddit, you guys. I just want to say, in defense of Reddit, there are some really, really, really great threads on Reddit that I admittedly sometimes get sucked into, and call me Alice, because that's another rabbit hole I can get stuck into. But they oftentimes have the goods. They have the facts. They have some real information in there. It's not all bad. It is not all bad. Oh, thank you, Patroness Glow. It's growing so quickly. We'll see. We'll see where we go. Yeah, that's probably true. I don't know. Is it true? I don't know. Oh, thank you, Scotty. Your code I have to say. Oh, thank you so much. Hi, Ray. How are you? I hope you had a lovely Thanksgiving. The way I ran to make that phone call and rushed back, I almost bent my fingernail back trying to open my computer. Do not bend your fingernail back. That is one of the most painful injuries that you could ever have. I know because I've done it. My daughter just did it the other day. She's like, what do I do? I'm like, you have to just put a Band-Aid on it and just wait for that nail to grow out because that is super painful. That is super painful. Thank you, Maureen. Thank you, Maureen. Thank you for loving my show. All right, my friends, where do we go from here? Do we go to the motion that the defense filed on Friday, which didn't even hit the court file until this morning, where they ask for a reduction of the verdict, a new trial. They ask for all the evidence to be thrown out. They ask for everything. Or do we go to plaintiff's response to the juror number 1 motion? You guys tell me. Thank you, beautiful messy ball. Part of the reason we like watching people like you, R.A. Jules, Law and Lumber versus major media outlets is because you aren't tied to any corporate agenda. Nope. This is my corporation. I am the CEO. I am the head MF in charge. And that is it. It's just me. It is just me. But I would like to have like a producer and somebody to do my research. But you know, maybe that'll come. Kind of like the morning show. God, I love that show. Absolutely. The response. Plaintiff's response. Yeah, okay. The thing is that it's long. So we're going to have to plaintiff's response. Pickle neck. Pickle Nuts. Plaintiff's response is a thing of beauty. All right then. I didn't get a chance to highlight it for you though. So we'll do our best with that. Let me just do a quick overview. It's worth the length, Janelle, huh? 150 pages. What? Yes, I did, Wendy. Yes, I did. The head MFIC. It's the HMFIC. That's what we call it. That is what we call it. Because you know I don't curse on this channel, so it doesn't matter. They find other reasons to demonetize me, whether I curse or not. They just demonetized the one I did on Sam Haskell the other night, where he's been accused of unaliving his wife and his in-laws because they found the wife's torso in a dumpster. I don't know. That was a copyright strike, so I don't remember what video I played in there. I guess I'll have to go back and edit. I hate editing. Oh, I just want to show you real quick, in case you haven't seen this, juror number 1's questionnaire, because they keep referring to this questionnaire. And I don't know how many of you have seen it. So let's look at his questionnaire now that we already know his name and it's out there. So, you know, I'm not doxing anyone, and I never would intentionally, but his name is out there. So let's look at this juror questionnaire and see if we can find anything that he could have potentially lied about in their, in their opinion, that would give a reason for him to be thrown out ab initio, going back to the beginning. I know some Latin, you guys. I know. That's pretty cool, right? All right, here is prospective juror questionnaire number one. So they may have had to fill out more than one questionnaire, and this was filled out by Paul. Every juror that came in had to fill out this questionnaire on September 14th of 2023. He was the first guy there for jury duty. He had to fill this out. Everybody had to fill this out. I don't know how they do voir dire in Florida, so I'm not going to pretend that I know. It was not, I don't believe it was televised, but in New York, we put 6 people in the box and we question those 6, and then we use our challenges on those 6 before we move on to other people. So when you have 6 in the box, you have all of their questionnaires in front of you. They hand you everyone has a copy of their questionnaire. So while you're asking them questions during voir dire to make sure that they can be fair and impartial and not, on one person's side and they don't have any biases, you have a copy of that questionnaire in front of you. And here's what they had to go from. He didn't put his date of birth on here, so good for him. You know what I hate? I hate when you go to CVS to pick up a prescription, and usually I go to the drive-thru, and that's the only one I'll go to. But if you're in the store, they want your date of birth, and they like shout it out. It's like you just want to give them the date and the day and date. And why do they need you? Why do you need my date of birth? Why do I need to tell you the year of my birth in front of all of these 400 people that are standing in line? I don't know. I just don't like that. That's just me. Okay, are you a citizen of the United States? Yes. Do you live in Sarasota County? Yes. Do you understand English? Yes. Can you read and write English? Yes. Have you ever been convicted of a crime? Convicted. It's very specific. He said no. Are there any criminal charges pending against you of which you are aware? No. Do you have any physical or mental disability that would interfere with your service as a juror? No. Marital status, married. Education, circle the highest level of education completed. He circled the circle after 2 years of college. Do you own your own business? No. Present occupation, retired. Last occupation, law enforcement for the city of Hialeah, Florida. I think that's how you pronounce it, Hialeah. If I'm wrong, you can always correct me, I don't mind. He had to give his spouse's name and her occupation, which is human resources. If you have children, please list ages and occupations. Age 26, occupation Walmart in the electronics department. Have you served as a juror previously? No. Are you a close friend or relative of a law enforcement officer? No. Have you or a member of your immediate family been A, victim of a crime? No. B, charged with a crime? Yes. C, witness in a criminal case? No. Approximately how many years have you lived in this area? 11 years. Have you had previous military experience? No. Clubs or organizations you belong to? None. Magazines or newspapers that you read? None. Hobbies or recreational interests? Camping, kayaking. Maybe, I'm stepping aside for a second here. Maybe for future, since they seem to think that it's so important, there should be a question in their jury questionnaire that says, do you watch YouTube? If so, what YouTube channels do you watch regularly? Maybe that should be in there because he doesn't seem to think, or the defense doesn't seem to think, that anybody should watch YouTube because everyone is so biased and plaintiff oriented. Right. Do you post on Facebook? Yeah, maybe they should have asked that. Cali girl, do you post on Facebook? Do you have an Instagram? Do you look at TikTok? Are you on Reddit? What's your Reddit username? What's your Facebook username? What's your Instagram username? Because remember, now that we're going to be a juror, we're going to give up every expectation of privacy that we ever had if we listen to the way the defense wants it. And then under penalties of perjury, I declare that I have read he likes camping and kayaking. I'm not sure if I said that. It was just hobbies or recreational interests. Under penalties of perjury, I declare that I have read the foregoing juror questionnaire and swear or affirm that the facts stated in it are true. And he signed it and dated it September 14th of 23. And then they ask about juror compensation because in New York, if your employer pays you for jury duty, the state of New York will not pay you. If you are not employed or your employer does not pay you, you make a whopping $40 a day in New York. I do not know what it is in Florida, probably less. So he says no, because he's unemployed and he's retired. Here's the supplemental juror questionnaire. Do you know or think you know the judge? And then it puts the judge's name, Judge Hunter W. Carroll, yes or no? No. Do you think you know? It says, do you know or think you know any of the parties? Jack, Maya, Esteta Beata, Johns Hopkins, Catherine Beatty. Because remember, when this case went to trial, when they picked the jury in this case, the only two remaining defendants were the hospital and Kathy Beatty. The plaintiffs discontinued the case against Kathy Beatty before openings, and I'm not sure why. And in the defense motion, they actually say that Kathy Beatty was discontinued from the case without any settlement. So she didn't pay anything. They let her out of the case. I think it's because the defendant hospital had already accepted responsibility for her actions. And so they didn't need her as a defendant. Maybe they didn't want to complicate it. Although, as you know, this case was very, very, very complicated regardless. He checked no to all of those boxes. And then they give a list of 96 witnesses, 97 potential witnesses. And they say, do you know or think you know any of the potential witnesses? And they're listed alphabetically. And it is every single person we saw testify and then some. Every single person that they read a deposition snippet from, or we saw a video deposition of during the trial, and he checked no to every single one of those boxes. Now, what the defense is saying, we get down to the Deborah Salisbury. Deborah Salisbury is the attorney who was in the documentary, Take Care of Maya. She represented Jack and Beata. I think it was Jack and Beata, right? She represented the parents in the dependency court action and the shelter hearings. She was their attorney. The defense is saying that juror number 1's current wife had some sort of a domestic or family court proceeding in 2007, and her attorney was, at that time, Deborah Salisbury. They're saying that he intentionally lied on this form and said that he did not know her. I submit to you that from what I have heard and what you have told me, juror number 1 and his current wife, Yolanda, were not together in 2007, and he likely has no idea who Deborah Salisbury is, that his current wife had Deborah Salisbury representing her in whatever this 2007 action was. And it's quite possible that he absolutely never heard the name before. So if we're looking for things that he intentionally lied about on this form to get him out of the box, oh, that's interesting, out of the box. I wonder if do you think that analogy or that cliche comes from jury duty, or do you think it comes from baseball? Out of the box, get him out of the box. What do you think? Just a thought. Do you have any family members currently enrolled at Venice High School or were enrolled at Venice High School last year? No. Do you have any of your close friends or family members work for or have worked for the Florida DCF? No. Have you or any of your close friends or family members had a child sheltered into protective custody by any government agency such as the Florida DCF? No. Do you hold any strong opinions concerning the Florida Department of Children and Families or its ability to take children into protective custody? No. They are going to say, but curiously, they did not attach this questionnaire as an exhibit to their reply, although I believe it was attached to the original motion. We don't know. We don't know what happened during that 2002 proceeding. Whether DCF was involved, we don't know. They're making a lot of assumptions here. But they're going to say that he lied about that. I think that's what they're saying. 5, do you or any of your close friends or family members work for or have worked for the Johns Hopkins All Children's Hospital, St. Petersburg? Nope. Have you or any of it says, have you or any of our close friends? No, it should say your close friends or family members been a patient at Johns Hopkins? No. Do you or any of your close friends or family members work for or have worked for the Tampa General Hospital? No. Have you or any of your close friends or family members made a claim for medical malpractice? No. This is interesting. Have you or any of your close friends or family members known a person who died by suicide? He answered yes. He answered yes. So they knew that, and they still kept him on the jury. It'll be interesting to know if they questioned him about that during voir dire. I don't know if they have transcripts of the questions they asked during voir dire, but that obviously would be better than their blanket assertions that he lied on his forms if he was questioned about these things during voir dire, and they have a transcript of it. Haven't seen that yet. Do you hold any strong opinions about death by suicide? No. Do you have any strong opinions about religion, including the Roman Catholic religion? Nope. Have you seen the movie Take Care of Maya, which previously streamed on Netflix? No. Even if you have not seen the movie Take Care of Maya, have you had any conversations or overheard any conversations regarding that movie or concerning that movie? No. Have you read any stories in print or online, heard any podcasts, viewed any previews or segments of the movie Take Care of Maya, or read any books about Maya Kowalski, her 2016 admission to Johns Hopkins All Children's Hospital in St. Petersburg, Florida, or the Kowalski family's interactions with Florida's DCF or the dependency court? No. Have you read any news accounts of this matter, including those in the Sarasota Herald Tribune, Venice Gondolier, or Tampa Bay Times, or seen television news accounts of this matter? Nope. Is there anything that you think the judge or the attorney should know or would like to know about you or your opinions? Nope. And he says, under penalties of perjury, I declare that I have read the foregoing supplemental juror questionnaire and swear or affirm that the facts in it are true. Again, he signed it and dated it September 14th of 2023. Let's go to the chat. Hello, Duty Ron. Thank you so much, Duty Ron, for your super chat. Hi, guys. I'm here to support my favorite attorney, Melanie Little. Thank you. Thank you for letting me be your favorite attorney. I know there are so many options on YouTube, and the fact that you chose me to be your favorite, that makes me really happy because you're my favorite too. Susan Agnello, thank you so much. You adore my chats. Thank you for your super chat. I really appreciate you. And Beach Lover, also thank you for your super chat. Oh, hey, CRPS Warrior, loves you all. We love you too. And in the chat. And Callie Girl, thank you so much for your super sticker. Susan Agnello, thank you so much for your super sticker. And Ray became a new member. Thank you for becoming a member of Melanie's Little Cupcakes. Thank you so very much. Anna MD says, this should be a question on the juror questionnaire. Do you or any of your family and friends are able to have critical thinking? I mean, if we believe what the defense says, then juror number one's wife told him what to say. Bodie, that's right. Cops do see a lot of suicides. That's right. I think the question was specific to family members or friends, but yeah, they do. 100%. Oh, thanks, Darlene. Duty Ron stopped by, but he had to go. I know he's got to eat dinner. I'm sure. Mary, you want to see the plaintiff, the transcript is in the plaintiff's response. The transcript of what year? Oh, that's interesting. All right. Ray, have you or any of your close friends or family members known? How do you even answer that? Yeah, I know. Like, I don't know what my friends know or don't know. I don't know. Hi, love and respect to all from Duty Ron. Yes, everyone, go subscribe to Duty Ron if you're not already. We have a lot of cross-pollinators here who watch us both. Scott says if they didn't question him, it's on them. He disclosed it. That's right. That is correct. Oh, hello, Peter Franzo. Oh, putting him in the box is a law enforcement term. Put the suspect in the area for questioning by law enforcement. Yes, that's it. That's the box too. That's probably where it came from. Put him in the box. Get him out of the box. Yes, Rochelle, right. He knows someone who committed suicide. Interesting. Yeah. Lita, they didn't know that information because they got it from the Reddit group. Bodhi says, yeah, because we all know the lawyer that our ex hired many years ago, right? Because they're a topic of every conversation. Out of the box, I think, is a hockey term. Yes, 5 for fighting in the box. Could be. Could be. Very could be. All right. We are going to go to, even if the wife told him about the situation, Mara says, which person would you ask or tell? Also, my lawyer was X and Y, because why would you? Yeah, exactly. Like, why would it come up? Jeff says, I would concur with the assessment on that. All righty. All right, so let's go to plaintiff's response. If I can find where I put it. That's not it. Talk amongst yourselves for a moment. All right, here we go. Okay. Everybody can, well, a lot of people are not going to read this on the screen because it is hard to read on the screen. All right. This is plaintiff's response to defendant Johns Hopkins All Children's Hospital's motion for a new trial based on juror misconduct. Motion for juror interview, motion to open discovery into evidence of juror misconduct, and emergency motion to preserve evidence. So let's see if I can make this somehow a little bit bigger. No, because that screws with that. Is what it is. All right. Plaintiffs by and through its attorneys. Here's our opposition argument. The motion, which really should be entitled Juror Misconduct by Proxy, should be denied in its entirety for the following reasons. Oh, Munchausen by proxy. See what they did there? A little play on words. I like that. It's good to open with a joke. Nothing funny about this, by the way, but here's why it should be denied. Here's our reasons. A, defendant failed to preserve its juror number 1 challenge. Besides asserting an incorrect standard and basing its allegations on asserted posts of people other than juror number 1, defendant failed to preserve the arguments it now makes after the verdict. The pre-verdict information on which defendant relies was available, and it appears known to defendant before the verdict, yet defendant waited to see how the verdict came in before bringing these assertions to the court. Had it acted timely, if its claims had any merit, they could have been addressed before this 9-week trial went to the jury. That's interesting. And a good point. Over 20 years ago, the Florida Supreme Court stated the court system is already overburdened and does not have the luxury of allowing jury verdicts to unravel or be subject to attack because of information which could have been reasonably obtained before the trial begins. Same rationale applies to information that could have been discovered during the trial, when an alternate juror could move up to deliberate. In 2002, the court said, in a perfect world, access to the information would be immediately available in all courtrooms or actually provided as jury pool information. Because of advances in technology, that day has arrived, and it may be appropriate for the courts to revisit whether parties have a duty to investigate juror backgrounds before a verdict. But the court need not reach that issue to see that defendant has failed to preserve its argument here. We'll sort of skim this a little bit, unless you want me to stop for something, that is completely so important, but I'm going to skim it with you. So they're saying the defense bases its motion largely on internet posts during the trial. And they say that, as the judge said, the jurors are free to discuss their service when the trial's over. Those materials were available to the defense in real time. The defendant claims it strains credulity to believe that juror number 1 and his wife were not communicating with each other during the trial. Defendant is wrong. This is exactly what we were saying the other day, right? That it strains credulity. Ed, I don't know if you're in here, but Ed said that should be the next t-shirt. Strains credulity. Because really, how often do you even hear that word credulity? Credulity. I don't know. Tongue twister. First, the court told the jurors repeatedly that they were not to discuss the case with anyone, even family members, as noted below. To engage in the unsupported assumption defendant posits would mean there could never be a married juror, so it does not strain credulity to believe jurors follow instructions. Footnote number 1. That's the Florida Standard Jury Instruction explanation of the trial procedure. Second, as discussed below, evidence shows defense counsel was actively engaging with members of the public through the internet during the trial. And therefore, all the pre-verdict posts defendant complains about in the motion should be considered known to the defense team before the verdict. Wait, evidence shows defense counsel was actively engaging with members of the public through the internet during the trial? Defense counsel? Well, that's going to get good. I mean, we knew about Ethan Shapiro's wife, but I didn't know that any of the defense attorneys were engaging with members of the public on the interwebs. Did you? Defendant has not denied it knew about these posts in the motion, and if it does, the members of the defense team should be placed under oath and questioned, but that should not be necessary. Quote, where a lawyer knows of an incident potentially compromising the jury before a verdict is returned, but fails to object or alert the court until after the verdict is announced, the incident may not be raised as a ground for a new trial. Okay, pickle nuts, thank you. So there is part about Edith Shapiro's wife. We said on the last stream that we were going to suggest that they do use that. The second district holds the same. All right, there's another case they're going to talk about, which we don't need to really talk about. Let's just talk about the case at hand, the case that we're discussing. Defendant has not presented legally sufficient prima facie evidence of misconduct by juror number 1, the correct legal standard for a juror interview. It says that the case law says that before a trial court can permit a juror interview, unless the moving party has made sworn factual allegations that, if true, would require a trial court to order a new trial. The court stated the case law on this topic allows of the fact-finding process inquiry only into the objective acts committed by or in the presence of the jury or a juror that might have compromised the integrity. Because defendant's motion contains no objective acts that were committed by or in the presence of juror number 1, defendant has failed to carry its burden. The motion supports the request to interview juror number 1 solely by inferring that he has violated the court's instructions based on the conduct of his wife and others. In effect, the motion asks the court to impute the actions and statements of juror number 1's wife and others to him. Misconduct by proxy. Excellent argument. Yeah, the motion talked a lot about his wife and a lot about Jules and a lot about things that he did or said after the verdict was rendered, after he was released, but they really didn't point to anything that he did during the trial, except for asking questions that they thought showed bias. But it's a fishing expedition, basically, like I said. Here's another case that involved a similar attempt to use assumptions and inferences to conclude that jurors had violated the court's instructions not to discuss the case. There, the trial court became aware during jury deliberations that a brother and sister served together on the jury until the brother, the alternate, was discharged. That's weird that they didn't know the brother and sister were on the jury to begin with. The trial court declared a mistrial. The court said, sua sponte means the trial court did that without even anybody asking for it. The court just did it on its own. The court said, I can make a presumption they are brother and sister, and I found out they have driven back and forth together. They must be talking about this. The appellate court, so the appellate court disagreed and said, even if there was a brother and sister on the trial and they drove to court together, that because it was based on assumptions and inferences rather from a competent record evidence, they overturned it. And it should not have been a mistrial. A motion seeking to interview jurors that is based on mere conclusory statements based on speculation and surmise that if interrogated, the jurors might have something to say that would be material to whether or not the court should award a new trial is insufficient. A motion for interview of a juror will fail when there was no suggestion in the record of any misconduct or irregularity on the part of any juror. Here, juror number 1's wife did not serve on the jury with her husband, and there's no reason to assume juror number 1 disobeyed the court's instructions not to discuss the case with anyone merely because he has a wife. Defendant acknowledges throughout the motion that it has no evidence juror number 1 violated his oath. See motion page 3, and this is what they said, quote, this person sets forth a reasonable basis for belief that juror number 1, the foreperson, engaged in presumptively prejudicial misconduct. Juror number 1's spouse's social media post highlighted her heavy personal bias in favor of the plaintiffs, a bias apparently shared by her husband, right? Apparently. It strains credulity to believe that juror number 1 and his wife were not discussing the case in violation of this court's instructions. Those are not objective acts committed by or in the presence of juror number 1 as required by Mailer, which is the case they cited. In the conclusion of the motion, defendant again acknowledges that it has no evidence of actual misconduct. Again, it strains credulity one more time to believe that juror number 1 and his wife were not sharing information regarding the case, particularly given the nature of their social media participation. Defendant does not have to prove, quote, actual misconduct to be entitled to a juror interview under Florida law. Rather, defendant only has to establish a reasonable belief that the misconduct occurred to be entitled to interview a juror regarding presumed misconduct. The circumstances here are very different from those in the cases that defendant cited. Reason being, in the other cases cited in the motion, the appropriateness of a juror interview or further court review was based on evidence of actual misconduct in which a juror or jurors participated, not inferences that the juror had participated. Right. And that's exactly what their motion was all inferences. They must have done this. They must have done that. He must have been biased. Defendant has cited no cases, and plaintiff is aware of none where a juror interview has been based on inferred conduct of a juror or conduct of third parties imputed to a juror, misconduct by proxy. I think they've just created a new legal term, misconduct by proxy. Good on you guys. Plaintiff's firm. The correct legal standard for a new trial based on alleged juror misconduct. They're saying that defense motion also states that, quote, potentially harmful juror misconduct is presumptively prejudicial, citing a case. This is an incomplete and therefore incorrect statement of the standard to determine whether alleged juror misconduct, if established, requires a new trial. The case is Amazon. They go on to discuss it. It says that Amazon held for the premise that it should be clearly understood that not all misconduct will vitiate a verdict, even though such conduct may be improper. It is necessary either to show that the prejudice resulted or that the misconduct was of such character as to raise a presumption of prejudice. Emphasis added. In other words, potentially harmful misconduct is presumptively prejudicial, but the defendant has the initial burden of establishing a prima facie case that the conduct is potentially prejudicial. So obviously plaintiffs are saying that the defense did not do that. They are not establishing that the conduct is potentially prejudicial 100% prima facie on its face. Prima facie means on its face, prejudicial. Defendant has provided no authority and plaintiff knows of none where the prima facie case of prejudicial conduct required to order a new trial is established purely by an inference or imputation of the conduct of others to the juror, i.e. misconduct by proxy. Thanks, reviewer, and thanks for your super chat. Defense continues to gaslight. Sounds like it to me, right? This is like gaslighting 101. Thank you so much for your super chat. Oh, thank you, reviewer one. You put it in there twice. Thank you. Thank you for, again, super sticker and a super chat. Appreciate you. The record regarding juror number 1's conduct or lack thereof. They're saying, like, at all jurors, he took an oath, and at every single break, the court asked everybody if they talked to anybody or formed any opinions or watched any media or follows the instructions, and juror number 1 always answered that he had. Florida recognizes a presumption that jurors will follow their oath. And as stated above, defendant acknowledges often throughout the motion that he has no evidence that juror number 1 in fact violated his oath. Like the motion, the supporting affidavit of defense counsel Shapiro only contained his suppositions and theorizations about whether juror number 1 in fact violated his oath and relies largely on the fact that juror number 1 and his wife are married. He kept saying that, like, they're married and they live together. They're household companions. What? They're household companions. So they are definitely of one mind, one body, one spirit. There's no way that either one can have an independent thought. Defendant cites no authority supporting the argument that improper juror communications can be inferred from the fact of a juror being married. Indeed, if that were a legally sufficient basis to challenge a verdict, every verdict in every case rendered by a married juror would be subject to challenge. The extent to which the motion reaches for any purported factual basis is best demonstrated by the reference to juror number 1's post-verdict online statement that, oh boy, I'm in trouble once again. From the two words, quote, once again, the defendant surmises the comment indicates that he knew from conversations with his spouse prior to being released from the courthouse that the defendant had moved to dismiss him as a juror. End quote. Patently, this is pure conjecture, and once the trial concluded, there would be nothing wrong with all the jurors learning what went on during the trial that they had not seen. I think, it's possible, I'm diverting from this for one moment, that perhaps he watched our stream last week and our conversation, and we might have actually written this response for him, or at least assisted. I hope that we assisted with our observations, because this is exactly what we were saying last week. It's exactly what we were saying. Footnote number 4, a husband stating that he is, quote, in trouble with his wife, end quote, in trouble again, or any variant of this is a commonplace expression used in everyday life as a humorous attempt to acknowledge any one of many possible wrongs, such as being late, forgetting to pick up milk, forgetting to feed the dog. It's therefore impossible to attribute any one circumstance to such a remark. Theorizing, the remark by juror number 1 referred to the defendant's motion to disqualify him as more pure conjecture and shows the Hail Mary nature of the defendant's motion. Scott, you said Hail Mary earlier. Were you, did you read this already? Did you already read this? Otherwise, all the matters that defendant contends show misconduct by juror number 1 are matters anyone watching the trial could know, just like we knew. Defendant has focused its fire against juror number 1 on 3 primary targets. 1, juror number 1 himself. 2, juror number 1's wife. And 3, a member of the public gallery and social media commentator known as Jules. Although defendant's motion is scattershot and the connections between each of these individuals' conduct and any so-called juror misconduct are never drawn by defendant, plaintiff will address each in turn to demonstrate the absence of any basis to establish juror misconduct. Juror number 1's alleged direct actions. Okay, yeah, we talked about this. The question about creature comforts, right? Creature comforts. So the defense was saying that juror number 1 must have watched Dr. Kirkpatrick's video on his website, because Dr. Kirkpatrick on his website talks about creature comforts. And so therefore he did some outside research, and therefore, obviously, that's misconduct. And then they say, first, it must be emphasized defendant does not stop at one claimed instance of internet research, but broadly claims without basis that juror number 1 inappropriately conducted internet research on one or more issues in this case. Despite that bold claim, defendant never tells the court or plaintiff what those other issues might be. There's only one issue arising from alleged internet research specified in defendant's motion. The motion states the phrase, quote, creature comfort was not used by any witness at trial, but it is used on Dr. Kirkpatrick's RSD Foundation website related to K-treatment. This statement is demonstrably and categorically false. And so many of you emailed to me the place where this was said in the trial, and I appreciate you for that. And they say this statement was made in Miss Rachel DeYoung's testimony on September 28th, 2023. She testified regarding so-called creature comforts. And there is the testimony, and they even give you a little link if you want to watch it on YouTube and tell you exactly where it is at 1 hour, 20 minutes, and 26 seconds. And Ms. DeYoung talks about creature comforts. But at home, she has her creature comforts, her dad, her brother, maybe her favorite show. She can call a friend. She's having a really bad time. Creature comforts on that day was discussed in open court. And as we know, juror number 1, just like all of the other jurors, was paying rapt attention to all of the testimony and taking copious notes. So take that. Juror number 1's use of the phrase creature comforts came 11 days later on October 9th, which was trial day 11. Juror number 1 asked, and this was juror number 1's question. I guess it was asked of Maya. Maya, during your stay at Johns Hopkins All Children's Hospital, you were at some time not able to view TV. Only a ticking wall clock was available to you. While you were at Johns Hopkins All Children's Hospital, did staff inquire if they could assist you in any way, such as adjust the TV channel, the volume, bring an item closer, further adjust your bed, not counting the 48-hour EKG? When it comes to creature comforts, were you made to feel comfortable, or were you made to just feel you were in a hostile place? Okay, this is important. Defense counsel did not object to this question or raise the allegation of outside internet research in its pre-verdict motion to disqualify juror number 1, although defendant had nearly a month to do so. And there's another link to another YouTube video where that question was read in court. Defense attempt to disparage juror number 1 is not only juror number 1's integrity is not only untimely, it overlooks the testimony of Mr. Young in favor of an unsupported theory that juror number 1 combed Dr. Kirkpatrick's RSD Foundation website to uncover the concept of creature comforts. Also, they're saying it's an urban dictionary and it's a common expression and it's a TV show, a movie, and other things, advertising campaign. Then they're talking about juror number 1's post-verdict comments. Juror number 1's post-verdict comments are immaterial to any consideration of alleged misconduct. The court expressly told the jury that they were free to talk or not talk to reveal their thoughts on the trial and their experience on the jury or not, based solely on each juror's discretion. They go through the information, the actual instruction. I'm not going to read that to you, but we all remember it, so I don't think we need to go through it. And if you'd like, you can probably go back and find that on YouTube. And we agree with that. Juror number 1 abided by his duty as a juror during trial, and the court already assessed juror number 1's alleged bias and prejudice against the defendant. And then they are saying that on November 5th, the court heard defendant's motion to disqualify juror number 1. It's already been addressed. The court denied it after a lengthy discussion on whether juror number 1 had displayed any sense of bias or prejudgment. The court unequivocally stated, and he gave a full opinion there, about why he did not think that it was proper to dismiss juror number 1 and reiterate later that it had no concerns about the bias of juror number 1. Oh, and then they're going to the questionnaire, which we just went over. Look at that. Defendants allege that juror number 1's juror questionnaire was incomplete, inaccurate, or otherwise deceitful. The single paragraph in the motion making this assertion, however, fails to proffer any verifiable facts. Number 1, about Deborah Salisbury. Defendant's motion asserts that juror number 1 never disclosed in his juror questionnaire during voir dire that Deborah Salisbury was involved in juror number 1's wife's 2007 domestic relations proceeding. Defendant, however, admits in footnote 11 that defense counsel does not know whether attorney Salisbury represented juror number 1's wife in that matter. And defendant does not claim the reference to domestic relations proceeding involved juror number 1. It did not. Nevertheless, defendant claims that Ms. Salisbury was definitively involved in juror number 1's wife's domestic relations proceeding. Going further, the defendant alleges misconduct because juror number 1 never disclosed this fact. What fact? Says the plaintiff. What fact? The juror questionnaire asked whether juror number 1 knew Deborah Salisbury, Esquire, not whether his wife knew her. The court should take judicial notice of a fact that apparently escapes defense counsel. Spouses can and do have different professional and social contacts and have separate lives before they marry. The paragraph in the motion addressing this Deborah Salisbury fact also does not establish that juror number 1's wife even knows Ms. Salisbury. Defendant draws no connection between what appears on the Sarasota County Court docket and any relationship between Ms. Salisbury and juror number 1's wife, which must first be established. Defendant offers nothing to show that juror number 1 has ever heard of Ms. Salisbury. Importantly, Ms. Salisbury never testified in this case. Oh, yeah, right. Even if defendant's counsel had been able to draw concrete connections between Ms. Salisbury and juror number 1's wife, and then from there demonstrated that juror number 1 also knew Ms. Salisbury based on Ms. Salisbury's alleged encounter with his wife some 16 years ago, the court and the parties would be left with a quandary. What possible difference would any of this make in a case where Miss Salisbury did not testify and her name was excised from any written communications to avoid injecting Chapter 39 independency court issues into the trial? As the court is well aware, the juror questionnaire provided in voir dire, juror questionnaires, were thorough, specific, and drafted with the intent to weed out any potential conflict. Juror number one's juror questionnaire indicates his honesty. He clearly indicated his law enforcement background and checked yes to criminal history for either himself or an immediate family member. Juror number one's wife alleged professional encounter with Miss Salisbury is a red herring and wholly irrelevant to juror number one's ability to assess this case as a juror. Great. Such a good point, says Mara. Dominique, so she didn't even testify. No, she didn't. That's interesting too, because she was in the documentary. That's where I remember her from. So that is interesting. Karen says, I can't believe the defense team think this is all okay and stoops this low to act this way because they lost. Scott, this could all be avoided in the future. Arranged marriages. Okay. Take Care of Maya documentary. Defendant makes an unsupported logical leap in alleging that despite juror number one denying in his juror questionnaire that he had ever seen the Take Care of Maya documentary on Netflix and further denying having any conversations or overhearing any conversations concerning Take Care of Maya, this seems unlikely. Tell me, people in the chat who are very interested in this case, is there anyone in the chat who did not see Take Care of Maya? That is it. Quote, this seems unlikely. That is the extent of the defendant's proffer to dispute juror number one's answers to the Take Care of Maya questions on the juror questionnaire. There are no facts offered to create a credible dispute over juror number one's answers to those questions. The rest of the direct attack on juror number one is conjecture based on juror number one's wife's so-called, quote, heavy engagement, investment, and close monitoring of the case, the court docket, and her following social media of the movie producers for the documentary, end quote. These hyperbolic, inflammatory, and imprecise allegations against juror number one's wife are addressed further below. Defendant has not demonstrated that juror number one has failed to disclose any facts on his juror questionnaire. Okay, and as we go to the chat, this is how many people who are so heavily emotionally invested in this trial have not watched it. Scott, Callista, Janelle Woodard, Jeanette Lawson, Anna MD, Bun Chan, Pam Spraggins, Darlene Wolf, Green-Eyed Lady 25. Ray didn't see it until after the trial. RTD did not see the documentary. Sharon Creates did not see it. DC PNW did not see it. Kirsten White did not see it. Oh, Callie girl, you did see it. Okay. Dominique has not seen it. Spooky Paws never saw it. Still hasn't. Truth Seeker, nope. Mujer Barroca has not seen it. Hi, Lynn. Lynn didn't watch it until the last week trial. It's ironic. Never has. Neither has Anshay Freeman. Still has not. Vicky, I did not watch any of the Take Care of Maya. Pickle Nuts, I don't have Netflix since my divorce. I'm sorry. You lost Netflix in the divorce. Oh, man. Thunder Horse has not. Magical Mary has not. Watched the trial, but not the documentary. Okay, so you see how many people in this chat who are very, very emotionally invested in this case and very interested in this case did not see this documentary. So really, does it strain credulity to assume that juror number one, a retired law enforcement professional, did not have any interest in watching the Take Care of Maya documentary on Netflix before this trial? Does it really? Thank you, reviewer, for your super chat. For those of us who've been following this closely, defense set up a false narrative, forcing the plaintiffs to argue against a straw man. Yeah, that is a great point, in addition to your other great points. Okay, so we are going to now talk about juror number one's wife's allegedly improper actions. Each and every time the following questions were asked by the court, countless times during the trial, juror number 1 and the rest of the jurors always answered in the affirmative. And again, this is everything we heard every single time the jury walked into the room. I want to confirm while you were away, you did not discuss the case amongst yourselves. You did no investigation. You received no information. Is that correct? Members of the jury, I want to confirm while you were away, you did not discuss this case amongst yourselves. You did no investigation, and you were right every single time. You didn't see any media accounts about this, correct? Nonetheless, and without any evidence that juror number 1's affirmative answers to these questions were untrue, defendant launches into unsupported theories about juror number 1's wife's influence over juror number 1's view of the evidence and the case during trial. Plaintiff observes that defendant's position that one spouse's knowledge or action should be attributed to the other means the defendant's arguments are unpreserved as discussed above. The extensive online involvement of lead defense counsel's wife discussed below leads to the conclusion that the defense knew all this conduct before the jury retired. The failure to timely raise it was a waiver. What? Snap, snap, snap. Again, we said this. First of all, as you recall, because we did a Thanksgiving Eve stream on this motion by the defense, they had 15 days to file it. The verdict came out November 9th. Therefore, 9 plus 15, I think, is 24. It had to be filed by November 24th. They have to count all the days, not just business days. That happened to be Thanksgiving Eve. While all of us were reading this motion together, some of you were making pies, some of you don't celebrate Thanksgiving, and you're just hanging out with me in your pajamas, and everyone had whatever alcoholic or non-alcoholic beverage they chose to drink while we went over this motion. And I said to you, whose Thanksgiving holiday is going to be ruined having to respond to this motion? Because that's like a big F you when somebody files a motion like right before a holiday. It's kind of like Shapiro was saying, I didn't get to go on a vacation, so nobody should have a vacation. But you notice this response to this motion was filed today, the Monday following the Thanksgiving holiday. So somebody at the plaintiff's firm, if not more than one person, spent their weekend in perhaps even their Thanksgiving day responding to this motion. Because this is a lengthy response, and this is not something that just takes an hour to draft. This takes countless hours, countless research, countless exhibit gathering, and all of this had to be done during the 4-day period that the law firm was closed for the Thanksgiving holiday. Happy Thanksgiving. And that's just kind of mean in and of itself, because they were drafting this the entire time that this trial was going on. This would have been drafted already. They were 100%. They had 100 people in the courtroom taking notes, researching. They have a much larger team, the defense does, than the plaintiff's firm. Correct. Yes, Jeanette, you're right. Being thankful is not just one day, and I'm thankful for all of you every single day. But lawyers do not get a lot of days off. They just don't. There's not a lot of court holidays. Most law firms close the day after Thanksgiving. I understand that a lot of people have to work the day after Thanksgiving, but usually the courts are closed, and therefore law firms are closed. It is really one of the very few days off that lawyers get. I'm just saying. Hi, Carmela. Thank you so much for your super chat. But why would Mr. Anderson agree to dismiss juror 1, then ask Jack keep him if there were this big conspiracy? I don't know. I am going to submit to you, and I don't know if they bring this up. Did they bring up jazz hands in the motion? Because if Jack saw the woman at the defense table do the jazz hands when Hold on, I can't even do a good impression because it's going to script the focus on my camera. When Greg Anderson said, okay, yeah, I think that's okay. We'll make juror number 1 an alternate. We'll bring in another one. Okay, I think that's okay. One of the women at the defense table, I'm not sure if she's an attorney or a paralegal or what, but she did the jazz hands like they were all excited. And I'm just saying, perhaps Jack saw that and said to Greg Anderson, hey, wait a second, they are real happy about this. I think, no, let's keep them. Did they talk about the jazz hands? I mean, we're getting there. Yes, Lita, they were visibly celebrating. So that information did not have to come from Jules, did not have to come from any improper anything other than Jack could have seen the jazz hands and said, wait a second, there's got to be a reason. There's got to be a reason why they don't want juror number 1. Therefore, I do want juror number 1, right? It's like, let's make a deal. Do you want what's in the box or do you want what's behind the curtain? You pick. And one is a cob of corn and the other one's a new car. Okay. Juror number 1's wife's social media and internet involvement. Juror number 1's wife's comment regarding juror number 1's expected questions to Detective Graham. Defendant alleges that juror number 1's wife's social media involvement indicates she had conversations with juror number 1 about this case. She points specifically to juror number 1's wife's comments on a YouTube stream. The juror law enforcement officer will be asking questions. We talked about this too. We said she probably knows her husband, knows that he's going to ask questions because she's watching the trial too. And there's no prohibition against a juror's spouse, brother, sister, child watching the trial that your father, brother, spouse, husband is a juror on. There's no prohibition about that. Essentially, defendant contends that the only explanation for juror number 1's wife's comment is impropriety. However, and as this court has pointed out, given juror number 1's background as a law enforcement officer, we could have expected that he was going to ask tough questions, sharp cross-examination type questions. This court also pointed out that 9 weeks into this trial, I can tell you without any sort of certainty that juror number 1 has been testing the evidence in this case, every single witness. Well, I don't think he asked a question today, but I think he asked a question on almost every single question that wasn't by deposition. Oh, then they talk about spousal privilege, which is something I also brought up the other day. And I was thinking, I don't know, is this like, will spousal privilege apply in Florida to this? Okay, so let's look at this footnote because this is interesting. Defendant's suggested remedy of depositions and interviews of juror number 1 and his spouse, which I thought was just crazy, and the fact that they want them to turn over their cell phones and everything else, fails to account for Florida's statute, Florida's spousal privilege. Juror number 1 and his wife have an absolute privilege to refute okay, start again. Juror number 1 and his wife have an absolute privilege to refuse to disclose their communications. Notably, juror number 1's wife has the right to prevent juror number 1 from disclosing his communications if they existed and if he was inclined to disclose them. There you go. It does apply. Ooh, then they're going to go into the doxing. Okay, hold on. The juror law enforcement officer will be asking questions. Let's go to footnote 8. Defendant filed the instant motion on the public docket and made no effort to keep the identities and social media aliases of juror number 1 and his wife out of the public eye. This has led to the predictable result, direct attacks on juror number 1 and his wife. For example, 1, on a post that says, "Hey, rabid Redditors, hope y'all have a nice holiday. How is everyone planning to spend that money we are getting paid by the defense to post on here? Dr. Quack Patrick has a sale. Buy 1K infusion, get propofol dilaudid for free." That is kind of funny in his defense. Note to juror number 1, bless your heart. One Redditor responded, "I think I'll buy some nice gold necklaces, purple attire, cheese whiz, hungry, hungry hippos." 2, One Redditor posted a photograph of juror number one's wife, and in response, another Redditor stated, "I think it's her. She has a very distinctive nose." Soon after, another photograph was posted of juror number one and his wife, and a comment in response reads, "Hippo shirts," with 3 skull emojis. 3. A Redditor posted one of juror number one's juror questions to Dr. Levy, and in response, another Redditor commented, Well, I definitely believe that juror number one knows where to get crack. See Exhibit A. Okay. This court went further to say, and I go back to, this is a person with a law enforcement background, and he's, in my mind, taking what's sharply conflicting evidence that both sides have skillfully and artfully put forward to this jury, and he's trying to make sense of it. Take a break for 1 second as I decompress from having read what I just read. Callista, yep, never going on jury. Don't want one team to dislike my response and then decide to dox me. I wonder if they're going to be admonished by the court for doing that. Not a classy thing to do. Not classy. A reviewer again coming in here with the super chat. Thank you so much. Thanks for your previous advocacy for victims and coverage of this. As a mental health provider to veterans, I see the eggheads get it wrong when treating patients. Dangerous to lack clinical humility. Yeah. And thank you for saying that, because so many of my viewers are afflicted not only with CRPS. Some of my viewers have been diagnosed with and suffering with CRPS, which used to be known as RSD, for 50 years. But so many other chronic pain disorders and other ailments or diseases that are difficult to diagnose, that take a long time to diagnose, that could have to go through several medical providers before they get an accurate diagnosis, and are medically gaslit for a very, very long time until a proper caring doctor with a proper diagnosis understands what's going on. And it's horrifying to me. This case opened up the dialogue on CRPS and a lot of other chronic pain disorders that we've never seen before. And listen, I'm here for it. I try to be on the right side, and we try to bring awareness to things. We're not embarrassed or ashamed or afraid to talk about the tough topics here. And thank you for appreciating that. I appreciate you for appreciating that. Thank you. I know that a lot of my CRPS warriors in the chat feel seen and heard and understood. And, this was not a case just about the Kowalskis. This was a case for, people with chronic pain disorders all over the world. And that's why I think there's worldwide interest in this case. And it's also shining a light on DCF and the privatized system, and the fact that you can bring your child into an emergency room, and based on a false allegation by a child abuse pediatrician who is private, works for a private company, you can have your parental rights stripped within less than a week and lose your parental rights. And that, my friends, is a really, really scary proposition. And I think a lot of people before this Kowalski trial did not know that, did not understand that. But it's real, and it happens every single day. And now you know. We all know. Jeanette says exactly. Yep. Yes, I said this too, Kamala. I wish the judge did not tell the number of the juror when reading the questions. I agree. I think they should have been done anonymously. I think they should have been handed to the court officer. They should have been shuffled up. And I don't think anybody should have been able to know who asked what question. I mean, I think some changes need to be made in this jury asking question system that we do not have here in New York. That's just my opinion. But as you know, I'm sticking to it. After 1 week of trial testimony and hearing the jurors' questions to witnesses, it became evident that juror number one was going to ask a lot of questions. He consistently asked questions throughout everybody's cases. The notion that juror number one's wife had improper communications with juror number one ahead of him asking questions to Detective Graham is meritless, Speculation. The court knew that he would ask questions. Plaintiff expected it. Perhaps defense counsel was surprised by his questions, or more likely, failed to appreciate that Detective Graham's abrasive nature and aggressive interrogation of Jack Kowalski would backfire. Touche. Touche. Next, juror number one's wife's comment regarding the jury deliberation note. Defendant's motion alleges that juror number one's wife's comment about the jury's deliberation note was the result of inside information that she could have only obtained from her husband, juror number one. The comment reads, quote, I think the note yesterday was frustrated jury that cannot reach money agreement and it will take days. Plaintiff's counsel had the same observation. So did we in the chat. So did we all. It was evident that the jury was frustrated, as indicated by their second note that read, quote, y'all, we have not been able to locate any of the calculations about future amounts. Witness Kirby was on Zoom and Whitney mentioned them today, and it was said that we'd have all this at deliberation. Well, if we do not have it, we ain't found it. Well, if we do not have it, I think it's supposed to say, well, if we do have it, we ain't found it in all these files. So without these witness figures, you'll be lucky if there's enough awarded to pay your gas to drive to court, or we'll be here until next Friday. That was the note that came out during deliberations. And that's the stream that we went back and we looked at the economist's testimony to see what it was that they were looking for. More importantly, juror number one's wife's sentiment that the jury was frustrated matched the overwhelming sentiment of the social media commenters and public followers of the trial. Thousands of comments were posted to this effect. Some below are some exemplars. Oh, this is fantastic. Tell me if you see your name in here, folks. Tell me what you think if you see your name. I don't know what stream this is because it doesn't say, and I don't know who Addie is a moderator for, but this could be Law and Crime, because I think that is their dark blue color. I don't know. Let me know what you think. CS1177, you'll be lucky if there's enough money awarded to buy your gas to get to court. Oh, well, here, we'll read the ones they highlighted. Jurors are angry. Michelle Darlene. P.O. I think the jury know the verdict by now, but have to put the numbers together. LOL, they mad ASF. Oh my gosh, the grammar. Seems the jurors want this to be done and they can't agree because they are missing info. Cat D, dude, jury wants to go home. How are the instructions going to keep them another day? I think they'll be seriously annoyed. They clearly do have a verdict. There are also a lot of comments in here that they did not highlight that are pro-defense. Oh, I was right. Beautiful Messy Ball says, Addie is a Law and Crime YouTube mod. Look at me. Thank you. Thank you very much. Thank you very much, everyone. Bun Chan says Addie is for Law and Crime. And here's some more. Yep. Speak Live, they are quoting chat, everyone. They are quoting chat. So make sure that what you put in chat, and listen, we try and keep it classy. And I tell you that at the beginning of every stream. Maybe I didn't do it today, but I'll say it now. We keep it classy. And the moderators are here for a reason. And my moderators police the chat. They are the best on YouTube. And they do not allow the gross, disgusting, bullying comments in the chat. These don't even seem to be bullying. These are just seem to show one side or the other. And that's perfectly fine. Everyone's allowed to an opinion. The jury is so annoyed. Seems the jurors want, oh, that's the same thing we just read. It doesn't look like it's different. Jury is trolling them. Here's more. So they just keep screenshots of the Law and Crime chat. Where do you think they got those from? Anyone? Anyone? Bueller? Anyone? Seeing if I notice any names from this chat in here. The jurors only want the amount to put in the verdict form. They sound fed up. I think they were annoyed they didn't have something they thought they would and were close to finishing if they'd had it. Juror number one's wife needed no inside information to interpret this note. The jury told the court that they were frustrated over the numerical values that they could not find. Next, we talk about juror number one's wife commenting regarding the jury not liking Kathy Beatty. Defendant also alleges that juror number one's wife had inside information from her husband based on her YouTube comment saying the jury, did not like Kathy Beatty or any of the witnesses defendant presented at trial the day prior. Defendant ignores the most rational explanation for the comment. Juror number one's wife was present in the courtroom on the day that Ms. Beatty testified and could see and assess the jury members' reactions to Ms. Beatty's non-credible testimony, as well as the other witnesses' testimony that day. Juror number one's wife's other social media post. Presence. Juror number one's wife's other social media presence. Hold on, I think I missed something in the chat here. Let me go back here for a second. Ray says, so now I know. First, I got to get a husband. Then I need to tell him I'm on a jury. Got it. Bodhi says, we say that stuff in every trial. Amber Gloria says, this is crazy. It is crazy. Clarabella, should we all be worried about posting our thoughts? It's kind of like, Big Brother is certainly watching. Certainly watching, I guess. Yeah, I guess you should. Skoda says, defense, if you're watching, I can confirm my partner only listened to me after I told him about the jury. Oh my goodness. Good night, Thunder Horse. Good night. Catch y'all later. Bodhi says, I wonder if Addie knows she made it into the motion. I don't know. She probably does by now. Lita says, well, Hunter was talking about goats and maggots. I still don't get that one either. I don't either. Goats and maggots. And then somebody told me it was from, I forget where, that it's an old expression from somewhere, if anybody remembers. Callista says, well, I mean, I also didn't like Kathy Beatty. Does that mean juror number one talked to me too? Yeah. Jeanette says, I could not go on other chats because my idea of trial was like an alien creature in the room. I know. That is so crazy. All right. Lori says, post mine, then come for me in the comments. That's what I say. And my merch says, come for me in the comments, because come for me in the comments. Respectfully. I don't mind. Defendant highlights multiple other social media comments made by juror number one's wife and focuses on her activity during live stream coverage of the trial on the Law and Lumber Recovery Addict and Lawyer You Know YouTube channels. Defendant states, on a near daily basis, juror number one's wife spent hours online engaged in commentary about the trial proceeding, both in real time and after the trial day had ended, and the jury was sent home, including her husband, juror number one, with whom she resided. The online presence of juror number one's wife undermines defendant's main premise that she must have discussed the trial with her husband. Because she was active online, she had ample opportunity to learn that way about what was going on in the trial. Despite the large amount of time juror number one's wife apparently devoted to online commentary about the trial, defendant cannot produce a single post indicating a discussion with her husband regarding the case at any point during the trial. In each instance, for every social media post by juror number one's wife, defense counsel ignores the common sense explanation. As an example, to explain juror number one's wife's comments reflecting concern over plaintiff's remaining time, cognizant of the 55-hour limit, defendant asked this rhetorical question. But why was juror number one's wife of the opinion that plaintiffs were running out of time if she wasn't discussing this case with her husband? Oh my God. The rhetorical question is easily answered. Anyone with even a casual interest in the trial heard the court repeatedly caution plaintiff's counsel about their remaining time. The remaining time on the shot clock was announced at the end of each trial day. Defendant's suggestion that juror number one had a unique perspective on the shot clock, which he must have shared with his wife, is absurd. In fact, the jury probably had the worst perspective on the issue since the shot clock announcements were made outside the jury's presence. Absolutely. Finally, juror number one's wife posted a comment saying, I think you are right, was in response to another post from an observer known as T-Bex as follows. T-Bex says, ma'am, being so combative makes it look like you care more about a narrative than about just giving honest testimony. Anderson should just sit down. The jury will ask the questions for him. This lady is acting like her job is at stake. Makes me wonder what management has said to her. Okay. Juror number one's wife monitoring of the court docket. Defendant next argues that juror number one's wife posts reflect that she was even monitoring the court's docket and reviewing court filings. This ignores that many of the YouTube channels and personalities mentioned on the previous page of defendant's motion and above regularly notify their audiences of recent filings by the parties and even read and analyze the motions live on YouTube with thousands of trial watchers tuning in. Juror number one's wife most likely obtained her knowledge of and comments on recent filings from these YouTube channels. But even if she were accessing the court's docket directly, she had every right to do so. Then they talk about her presence in the courtroom. Juror number one's wife. At no point was the jury instructed that their spouses were prohibited from observing the trial, either online or in person. All members of the public were welcome to attend, whether they had relationships with jurors, witnesses, lawyers, or parties. In fact, Mr. Shapiro's wife and children attended the trial on many days. Family members of Dr. Jenny Dolan and Dr. Tepa Sanchez also attended trial. A juror's wife attending one day of trial does not violate any law, rule, or oath, and certainly does not indicate juror misconduct. Next, Jules, a member of the viewing public's supposedly improper actions. Defendants focus on Jules, a member of the public who relayed her observations via social media and through various YouTube legal commentators throughout the trial, has no bearing on juror number one's conduct or plaintiff's counsel's actions in the courtroom. First, the de facto agent allegation. The allegation that Jules was a de facto agent of plaintiff or plaintiff's counsel is preposterous. Jules played no role in the plaintiff's trial strategy or decision-making, and her opinions were hers and hers alone. I guess Greg Anderson must have talked to Jules because he has a declaration, so he must say that he either spoke to her or they got a declaration from her. I'm not sure. Next, Jack Kowalski is allegedly smiling and nodding at Jules after Judge Carroll denied defendant's disqualification motion. The video that defendant cites shows Mr. Kowalski raising his eyebrows and turning to the gallery. There's the citation to Law and Crime Network. There's no footage or any indication that Mr. Kowalski is looking at Jules. In fact, Jules' head is down when the camera pans to her. One of plaintiff's expert witnesses, Dr. Scott Richards, was seated next to Jules, and Mr. Kowalski was looking at him, and as the two discussed the trial throughout. Internet, social media activity. Despite the absence of any demonstrated connection of this pre-verdict social media activity to juror number one, the motion complains that specifically the entire internet community was made aware of the heavy bias in plaintiff's favor on the part of the juror's wife, plainly compromising the integrity of the jury process. Emphasis in original. Leaving aside the question of how the defense was able to discern this information, what the entire internet community was aware of or thought does not constitute misconduct by juror number one. Moreover, defendant is hardly in a position to complain about internet and social media activity during the trial by third-party observers, as demonstrated by the defendant's own robust internet activity during trial. As shown in the screenshots attached here too, as Exhibit D, defense counsel Shapiro and other members of the defense team were receiving substantial ongoing feedback and support from the internet community throughout the trial. In a November 11th, 2023 message, Attorney Shapiro communicated that, oh my God, where did he communicate this? Hey, I want to thank you and everyone else who is sleuthing this so carefully and meticulously. I've gone through the Reddit thread on juror number one with almost 1,000 comments. Everyone on the defense team is monitoring this closely. If anyone in the community has comments to make, you can feel free to keep posting there because we are going to read all of it and put it towards emotion. It says emotion instead of a motion. I guess he was dictating. I agree that the idea the wife knew when a verdict was coming and what they were arguing about is shocking, and I hope the judge will feel the same way. I didn't know that. Did you guys know that? He posted wherever that was posted. Guess we'll find out. Also omitted from the motion is any mention of the active involvement of Attorney Shapiro's wife, Kisa, in a social media chat group during trial. As shown in the appendix below, Kisa Shapiro, undoubtedly an agent for the defendant, participated in the chat group by advocating defendant's trial positions, just as Jules, whom defendant erroneously claims was an agent for plaintiff, advocated positions favorable to plaintiff. Given defendant's position that the wife's knowledge should be imputed to the husband, Mr. Shapiro is deemed aware of all of Kisa Shapiro's posts during the trial, and by not objecting before the verdict has failed to preserve this entire issue. None of this internet activity is relevant to the relief sought in the motion without some objective act committed by or in the presence of the jury or a juror. Next, the relief requested in the motion cannot be based on post-verdict statements by juror number 1. And yeah, we've been through that. Everything he said after the verdict should not even address it. Next, the discovery requested in the motion, including a deposition of juror number 1, should be denied because they have produced no evidence. The motion repeatedly invokes protection of the, quote, integrity of the judicial system or process to justify the relief it seeks. The cynicism of such statements is remarkable in light of defense counsel's conduct at the end of the trial and after the verdict. To anyone watching the last day of trial, the disrespect toward the court's rulings and later at the verdict was palpable. After the court reiterated it was giving alternative verdict form questions to try and avoid the necessity of a retrial, defense counsel stated, "You don't know what the law is, so you're going to give the jury both options right now? Is that what you're going to do? I'm sorry, I object to that." Then came the following exchange. Wait, no, you have to read the last part of C. Did I skip something? Oh, you mean the exhibit? I don't know where that is right now. I'm just wondering how many more pages we're on page 33. I mean, is this okay? Then it goes to exhibits. Okay, fine. We're almost done. I just wanted to know how much more we had because if I can't read 24 more pages because I will not have a voice. Where is exhibit C? All right, the relief requested in the motion cannot be based on post-verdict statements by juror number 1. Okay, the motion also relies on statements by juror number 1 after the verdict. On discharging the jury, the court instructed the jurors that they were at liberty to comment publicly about the case, which is correct. See Florida Standard Jury Instruction 801.4, instruction upon the discharge of a jury. The lawyers and their representatives are not permitted to initiate any communications with you about the trial. However, you may speak to the lawyers or anyone else about the trial. It is certainly true that following the verdict, juror number 1 made known his decision to support the verdict for the plaintiff. There is nothing improper in that in our civil justice system. Indeed, all the jurors made their individual decisions public when they were polled after the verdict was read. Moreover, juror number 1's ultimate decision to support a verdict in favor of plaintiff cannot be considered as evidence that he made the decision through misconduct. The evidence properly admitted in this trial provided an ample basis for the jury to decide against the defendants. For example, near the end of the trial, the jury heard evidence from which it could be very reasonably conclude that the defendant had deliberately attempted to mislead it and the court about the defendant's accreditation status. If defendant is searching for a reason for juror number 1's decision to support plaintiff in the verdict, it need look no further than its conduct and the conduct of its counsel during trial. D, the discovery requested in the motion, including a deposition of juror number 1, should be denied. They're not showing any improper conduct. We talked about the integrity of the justice system. The verdict form. And then they give the following exchange between the judge and Mr. Hunter. Well, let's look at this footnote. All of defendants' counsel were present for the multi-day jury selection process and should be well aware of the extraordinary efforts undertaken by this court to protect the jurors' identities, rather than honor the court's efforts to protect jurors from exposure and public ridicule. Defendants' counsel have encouraged that conduct. In footnote 1 of defendant's motion, defendant exposed juror number 1's personal information and released his full name and physical address, thus inviting harassment. With full knowledge of the potential damage to juror number 1 and his spouse, defendant made no effort to comply with Florida Rule of Civil Procedure 1.431H by filing the motion or the identifying information confidentially or under seal. We said that. That's exactly what we said. It's exactly what we said. And when I pulled up that motion and that was there, I had to go back after that 3-hour live stream and redact all that information. I had to and it Z'd the chat, which is probably good. But I never in a million years would I have thought that they would have put that juror's address. Never in a million years would I have thought that. Okay, so the judge said, I'm just saying, Mr. Hunter, it seems what you're saying and what I'm hearing do not match. And Mr. Hunter said, and what I was also saying, Your Honor, was that you're only hearing second-long clips. You're not hearing the whole thing. You're not hearing the entire value, and it doesn't sound like you're prepared to listen to the whole matter. Oh, I remember this. We remember this. We're like, what did he just say? Judge said, whoa, time out, because that's a very serious statement you just made. Do you really think I'm not making balls and strikes calls? I've just eliminated a couple of items from their exhibits and I'm listening to your statement. So I just want to make sure, are you saying that I am closed-minded in this case? And then Mr. Hunter said, Judge, I'm suggesting that on this particular issue, you have indicated a predilection regarding the Heart Institute issue that I don't think I'm able to get past, and that's my problem with it. And on these particular clips where you're also seeing once again, and I hate to sound like broken record, but you've just listened. This is a town hall meeting that went on for some period of time. I don't know how long it was. They've got a whole clip of it. Okay. A whole clip of it I haven't seen. And frankly, don't to this moment, I know the entire source of, but you're reacting and visibly reacting to clips from that thing that are seconds long. You're not hearing the whole story. And that's my problem with the judge. Defense counsel Shapiro made the same false claims to the media and the public, stating in a media interview just outside the courthouse on November 1, 2023, that the hospital is credentialed by outside agencies that have found that the hospital has always operated under safe environments. And remember, we went over those outside of the courthouse interviews also. And what did I say? Anybody remember what I said during those interviews? I said, why are they doing this? Why are they giving these interviews? Also, as described in the declarations attached here too, as exhibits F and G, defense counsel Shapiro made repeated vulgar remarks while exiting the courtroom in a voice loud enough for everyone present to hear. Oh, they have a declaration from Gabrielle Carlson, who must have overheard it, and Connie Strump, who must have overheard it. Specifically, Attorney Shapiro said, effing ridiculous and effing scumbag family. Attorney Shapiro continued uttering similar expletives and derogatory comments as he walked down the hallway where members of the public and the media gathered throughout trial. Defense counsel's contempt for the jury is also demonstrated by a social media message from another member of the defense trial team and members of their law firm to Attorney Shapiro, which included a slur on the jury members as, quote, 6 people from the bus stop. Okay, so I think David Hughes is a named partner in that law firm, and here's something that David Hughes allegedly wrote that says, thank you for your continued help. Next time I'm in blank, I owe you one. If your other colleagues have insights, please pass along, specifically on the social media side. At this point, the medical arguments have already been made. And yes, a very important case. We'll never stop fighting for you guys. I'm ashamed of the outcome, especially after so many years, but you never know what 6 people from the bus stop can do. Mara says, this shocked me big time. Like, why would you say that in public? Holy smokes, says Jeanette Lawson. Anna MD says, Judge Carroll lives rent-free in my head saying honky-dory. Bodie says, oh, let's see. Scott says, Shapiro's lucky he didn't meet an angry bus stop person after the comments. Bodhi says the jurors didn't ask to be in the jury. Most people used to try and get out of jury duty, and I've been here on this channel trying to encourage everyone to do jury duty, to be on a jury. But I'm going to change my opinion. I'm going to change my opinion because after this, how can I recommend to anybody that they go sit on a jury? That they're going to be doxxed? I used to think it was such an important civic duty. This. They were talking about how, this is going to have such serious ramifications and such chilling effects on mandatory reporters. It's going to have chilling effects on people wanting to serve on a jury, sir, is what it's going to have. And they keep going. Nothing would be more. Oh, wait. SCOTUS says, Attorney Melanie Little, we want to be in the next motion. We feel left out. No, you know what? It's okay. It's all right. I prefer to be backstage. Well, I'm on stage here, but we don't need to be in the public eye. Although I do think that, people that were in, the people that were mentioned in the motion, the YouTubers, their channels are going to blow up if they haven't already. Yes, says Black Rose. Thank you for being a moderator tonight. Please like, subscribe, and hit the notification bell. Thank you. SCOTUS said, if they treated a juror like this, imagine how they treated Maya and Beata. That's a great point. Beautiful messy ball. They want to destroy the foundation of America and the faith in the Constitution and the justice system. It's happening more and more across the country. Clarabella. I don't think I'd ever be on a jury if they might drag out my old MySpace photos and my questionable taste in music. Let's finish this motion. Nothing would be more deleterious to the integrity of the judicial process than to subject people who have done their jury service to a deposition or an interview by lawyers capable of such behavior. There can be little doubt that a deposition or interview would be used to further vent defense counsel's frustration and anger on display on the last day of trial. Finally, in regard to the request for emergency relief regarding text messages and other electronic communications of juror number 1 and his spouse, the sole justification offered is the unsubstantiated statement in the motion that, quote, defendant has learned that individuals associated with juror number 1 and his wife have begun deleting social media posts, end quote. Such statements should be given no weight without further detail and an identification of the source. We said that too. Where are the receipts on that? You got receipts on everything else. Where are the receipts? E, defendant supplement to motion for a new trial based on juror misconduct, blah, 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 blah. Okay. Oh, the supplement. Oh, so they already got the supplement. Oh, okay. So we read the supplement and they're already including the supplement in their response. That's crazy. I'm excited that they did that because they didn't have to do another response. Plaintiffs are aware that at 11:54 a.m. on November 27th, defendant filed a supplement to its motion, bringing in extraneous issues in an attempt to slander juror number 1 further. Plaintiffs do not believe the supplement merits a response, but if the court disagrees, plaintiff requests an extended deadline. Yeah, imagine they have this ready to go. It's all copied, however many copies they need of this 144-page response. They got all their exhibits number. They got all the pages number. It's collated. It's stapled. It's filed. It's got blue backs on it. And now they see this other thing was filed and they got to say, put the brakes on, go back to the office, insert this paragraph, recollate, refile, restaple, re-exhibit. But they did it. Supplemental motion will rest on speculation from a matter over 20 years old. Additionally, defendant's supplement asserts that it is reasonable to assume that juror number 1 may have harbored ill feelings towards the DCF or, at a minimum, an allegiance in favor of a party accused of suspected child abuse, like the late Beata Kowalski. The prospective juror questionnaire utilized in this case included the following questions. Have you or any of your close friends or family members had a child sheltered into protective custody by any government agency such as the Florida DCF? And do you hold any strong opinions concerning the DCF or its ability to take children into protective custody? Juror number 1 answered no to both questions. It is not, quote, reasonable to assume, end quote, juror number 1 had feelings the defense speculates about when juror number 1 answered no to having any strong opinions concerning the DCF. Furthermore, the defendant asked no questions of this witness about any experiences with DCF. See Exhibit H. Oh, you guys are right. They have the voir dire transcript in here. It was love at first sight for defense counsel and juror number 1. There's a t-shirt. It was love at first sight for defense counsel and juror number 1 with like a big heart around it or something. As shown above, the post-trial allegations are irrelevant and defendant is in no position to complain about impropriety. As shown above, the post-trial allegations are irrelevant and defendant is in no position to complain about impropriety. Wherefore, we want you to deny it all, judge, deny it all. Signed, everyone at the firm. And buyer's remorse. Yes, reviewer, buyer's remorse. That would be a great t-shirt. Let's just take a little bit of a short break from this before we move on to the exhibits. Whew, that's a lot of reading. I was not going to do this tonight, you guys. I mean, tell me, don't you think it's boring when I just read to you the whole time? I had prepared like a whole synopsis of that other motion that they made on Friday that some people got a hold of by Saturday, and they were already commenting on it and doing YouTube streams on it. And I thought, it's not in the official court file. I'm not going to do it because like I can't source that and I don't know that it's real, and I'm all about the facts and I'm all about giving you guys the real, the real info. And then if I had some draft of some motion that wasn't even the real thing that was filed with the court and I came on and started talking to you guys about it, I would feel so embarrassed if it wasn't the real thing. But somebody else, I guess, had a source and was able to get a copy of it that even before it hit the docket. So hot off the press to them. But that's not something that I could do in good conscience. So thank you. Oh, thanks. Not boring at all, huh? We appreciate you. Thanks, Pam. Thank you so much. That's what we should do, Skoda. Yeah. Let's do a New York City meetup and take a group picture at a bus stop. Yeah, let's do that. All right. You want to set that up? Oh, beautiful, messy. Boss says, as not at all. As someone who suffers with chronic migraine, I appreciate having the documents read to me. Oh, good. Okay. All right. I feel like it would be boring. Mara, it's great when we get first-time reactions to motions, especially if they're spicy like this one. Yeah. Amber, Gloria, court documents with Melanie, a warm cup of milk before bed. Oh, that's nice. Oh, here's recovery addict. Great take, Melanie. Oh my God, Scott, I would totally invite you in. You want to come in? Do I have your email? I'll send you an invite if you want to come in. Just put it in the chat. Or I don't know, maybe you're in your pajamas and you don't want to come in. But how do you feel about being named in this motion? Did your channel blow up? Did you explode? Did you get tons and tons of new subscribers? How did it work out for you? Yeah, you're in your PJs. All right, you want to come on some other time? Now that you exploded, you're a really big deal around here. I don't know if you know this, but you're a really big deal around here. And for those of you who know what movie that's from, put it in the chat. Put it in the chat. I don't know if you know this, but I'm a really big deal around here. Let's see who gets it first. We'll give something away. Sure you want to come in? Or sure you're in your pajamas? Or you want to come another time? You know how it is when you're trying to man the stream and watch the chat, and I'm a one-woman show. I think you are too. I don't have any tech support. Thank you, Jason. It's Anchorman. That's Anchorman. Will Ferrell is one of my favorite celebrities in the whole world. I love me some Will Ferrell. I think some of his stuff that he did on Saturday Night Live was some of the funniest stuff I've ever seen. I mean, from the cheerleader guy to the Christmas. Okay, another time. Thank you. Thank you for coming in and saying hello. Everyone loves you so much. When they're doing the Christmas thing and they're spinning around singing on that thing and everyone starts getting sick. Hilarious. I love Will Ferrell too. I love Will Ferrell. Yep. We need more cowbell. We need more cowbell. One of the Saturday Night Live cast members, He used to be the longest running cast member on Saturday Night Live until I think now Keenan, I think, is the longest running cast member. Is also a dear friend of mine, and I also represented him in a car accident case years ago when he was doing a stand-up show in Sag Harbor. It was on page 6. It's the only time I've ever been on page 6 in the New York Post. And I was like, I'm gonna get on page 6 somehow. And it was probably, I don't know, 10 or 15 years ago when I represented him in a car accident, and I made page 6, and it was like, this person's attorney, Melanie Little, says blah, 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 blah. I'm like, I made page 6 and it wasn't for a bad reason. Nope, not The Office. It was from Anchorman. Oh, look, here's Recovery Addicts channel. Everyone go subscribe. I'm sure you already do. Right, Donna? Thank you, Donna, for putting that in there. But yeah, totally go subscribe to Recovery Addicts. He's very kind, and he has a very kind stream. And he's a really cool dude. And he's really like genuine and like vulnerable. Like I wasn't sure like what his channel was about. And when people started saying like recovery addict, I thought maybe it was like because we do a lot of streams here about alcoholism and addiction and loving an addict and loving an alcoholic. I don't really know if that has anything to do with his spiel or shtick, but I love the fact that his channel has blown up because I think he deserves it. Look, there's people out there who deserve it, and there's people out there who quite frankly don't. There's a lot of mean people on YouTube, I'm learning. And luckily, I have Miss Donna Marie, the queen of the mods, who often will go into the comments on the bottom of videos and delete all the mean stuff about me before I even see it. Like when they were making fun of my eyebrow. I mean, I got like the crazy stuff that people write. And sometimes, because I do say come for me in the comments, I'll take the meanest comment and I'll pin it to the top of the video so that it's the first thing everyone sees. And then all you guys are so nice to come in and defend me. But it's like, how dare you? How dare you troll around YouTube just to come in and say something nasty about me personally? Like, you don't like it, change the channel. There's a million other people out there you can watch. You can watch videos with robot voices, just showing you a montage of photos of celebrities or anything else. You don't need to watch me, but you also do need to stop and say something nasty. Because really, if you got that much time on your hands, then I just feel sorry for you. I really feel sorry for you. Oh, do I like The Office? Someone says, yes, I do. I do like The Office. I have a fever. The only coffee offered is more cowbell, says Honey 2800. Yeah, there's another show that I find really, really funny. And it was actually on today. It's one of the few movies that I'll watch every single time I'm going through the guide. Wedding Crashers. Every single time I will watch it because every single time I watch it, it's hilarious. Any one of the Meet the Parents, Meet the Fockers, the Ben Stiller shows, hilarious. And also there's an old movie. Does anybody know this movie called Office Space? Jennifer Aniston is in it. And it's about a guy who just like, I guess like he quits his job. And like the more he hates his job and the more he wants to quit, the more they want to keep him. I forget who else is in it. But yeah, Wedding Crashers is one of my favorite. Office Space. That's right. Isn't that great? Oh, hi, BH. He was addicted to gaming. He's recovering addict. Oh, that's right. I did see that on one of his streams, right? A gaming addict. That's right. And now instead, he's just addicted to talking to all of you on YouTube. So isn't that such a much better way to channel your energy? I don't know. I never got into, yeah, the stapler, beautiful messy ball. Never got into gaming. I don't know why. My kids are into it. Minecraft, Fortnite, Roblox. Never. Oh, Malane, you like it too? Office Space, love it. That's one of the things that if it's on, I will watch it every single time it's on. Cindy Burke loves it too. Yep. Did you take my stapler? You guys know what I'm talking about. You're picking up what I'm laying down around here. Oh, that is so funny. All right. Shall we go back to the exhibits now? We're only 2:15 into this. So let us see. Even when I don't agree, I enjoy your take, says Missy Rodriguez. Thank you. And I listen, I am one for debate. And listen, if we did that other motion tonight that I had planned to do tonight, the one about reducing the verdict and overturning some of the decisions and, doing a directed verdict and giving a new trial. my opinions are very different on that motion than they are on this motion, because, and I say this all the time, I am a constitutionalist, and I believe in procedure, and I believe in the rules of the court and the rules of law. And this was a case of first impression in many ways, especially when it came to the unaliving of Beata and whether or not the hospital owes her a duty. And I had said this from the beginning. So my opinion would be very different tonight if we were talking about that other motion, but I'm not afraid to talk about it because I think it's important. And I think that they had some things in that motion right. And there are some things that may be overturned, and there may be some numbers that are reduced. But I will say this: just settle the case. Just settle the case. Everybody, settle the case. Because this does not need to go on forever and ever and ever, and it will. It will. And a lot of times we all have emotions about this case, and we all have very strong opinions about this case for either side. But the best thing that could happen is that this case settles for an amount that's acceptable to the family. They're never going to pay $261 million. I will tell you right now. I will tell you that that number may not be sustainable in the state of Florida. And based on some of the arguments they made in that motion for remittitor, which is asking the court to reduce the amount of the verdict and or for a new trial and or for a directed verdict, then hey, if you don't want to give us this, we'll take that. And if you don't want to give us that, we'll take this. And if you don't want to give us that, then please give us this. And to have this go on and on and on and on, the case is not over until the check clears. Not over until the check clears. So $6,000, no, there's a lot of rumors about what was offered, what wasn't offered. Settlement discussions are always confidential, unlike juror names and addresses. Settlement discussions are always confidential. So we don't really know, unless the family has come out and said this is how much they offered, unless the plaintiff's attorney has said this is how much they offer. I'm not going to believe anybody who says anything about anything with regard to any settlements. That's all. That's all I got to say about that. But the best thing for everyone is that this case would settle for a number that is acceptable to everyone, and just say goodbye, put it to bed. Let's all start to take a deep breath and maybe move on, because I thought we were done with this case. I really did. I mean, I knew there was going to be some post-trial motions, but not as salty as these ones are. So it is emotionally draining. Thank you, Anna. It's emotionally draining for everyone. Oh, you started Team J Hatch. Now you can't even. See, like a lot of people shifted their opinions during this trial. Thank you, Patroness Glow. And yeah, listen, if you are shopping on Amazon anyway, you're shopping there anyway. If you're going to go through my link, no matter what you buy, whether it's on my list of recommended items or not, somehow it supports the channel. I don't really know how. I just got like a $14 credit on my Amazon. I don't even know how, because maybe people bought $10,000 worth of stuff and they gave me $14, and that doesn't even pay for the cat food that I needed to order. But it's a great way to support the channel if you want to support the channel. That's all. But thank you. All right. Let's go back to Kisa Shapiro's posts, who may or may not be Lisa Shapiro, and she just tried to change her name a little bit. I'm not sure. Is her name Lisa? Is it Kisa? I don't really know. Oh, thanks, Tiff. Tiff's shopping there right now. Oh, girl, I am like a Christmas Eve shopper. My office was for many, many years, for 10 or 15 years, 20 years maybe, in Garden City, Long Island, which is a very shishy place. And across from my office was Bloomingdale's, Saks, and Lord & Taylor. And I would be there on Christmas Eve, like with all of the men, not to say that, men are last minute shoppers, but it was me and all these men, like having no idea, like pie-eyed, like, well, there's nothing left for us to buy. I was always a Christmas Eve shopper. Luckily, it was right across the street from my office. Okay. Okay, so here's what Kisa was saying. Somebody said, oh, yeah, they were. There's lots of documentation showing many of Maya's nurses and doctors thought she was faking it. One doctor referred to it in her notes as a charade. And Kisa said, I suppose on some level that's true. We've definitely heard evidence that there was a psych component. I guess in light of the report discussed today done by Dr. Lewis, it's hard to believe that there wasn't, though. Okay. Then she says, again, I was referring to the mom's psych issues, not Maya's. And she says, I don't think they're talking about routine amounts of prescribed K, though, here. The extremely large amounts Maya was given, especially as a child, all in caps, could have easily killed her. And we need to be honest. Some parents sadly do put their children at risk. I think it's normal to view this case from your own perspective as a parent, but not one person in this group can definitively say Beata didn't suffer from some kind of psychiatric disorder. The whole story is just sad in any way you look at it. Yeah, she's putting her opinions out there loud and clear. Saying K can also be lethal, though, considering the alarmingly high doses of K that Maya was receiving. It makes sense to me that doctors were fearful that she could die if that course of treatment continued. And the fact that she has improved so dramatically since her hospitalization at JHatch, I don't believe she's had any K since, does make me question that course of treatment for Maya, not others with the disease, and calls into question her mom's mental health. It honestly seems like JHatch potentially saved Maya's life. And listen, a lot of people felt that way. And she was out there trying to influence public opinion. And or she was out there giving her opinions, which may or may not have influenced public opinion, which is the same thing that juror number one's wife did, but not to this detailed extent. So you can't use it as a shield and a sword. Defense, you can't come out with a sword saying, juror number one's wife posted all this stuff, and therefore this whole verdict should be overturned because that is definitely juror misconduct. And then use it as a shield and say, but Your Honor, even though my wife was posting stuff, that doesn't really mean anything. It would never influence anybody. Doesn't matter what my wife's. You can't, it doesn't work both ways, you guys. Do you see the logic? Am I being illogical? Again, and she goes into excruciating detail in her posts. Correct me if I'm wrong, but I think the dose they were seeking wasn't offered by any facility in the United States. That's why they flew to Mexico. Again, I'm so sorry for what you've been through and continue to go through with this awful disease. Though I understand the common link of CRPS between your story and Maya's, it just sounds like the treatment pushed upon Maya was reckless. Ketamine can kill. Even Maya was told that she could die from it. So she's going into excruciating detail, and she's probably talking about things that the jury is not going to hear about. Maybe she is, maybe she's not. I don't know. But, here she's saying, I don't believe that this is what the case is about CRPS. I don't think anyone's trying to prove or disprove that Maya has CRPS. It's just about the dangerous levels of K she was subjected to. And she was very vocal. Very vocal. I'm going to not read every single one of these because we're only on page 40. But Exhibit A. This is that the Dr. Quack Patrick. Hey, rabid Reddit. Okay, this is a Reddit post by who? I don't know. Hope y'all have a nice. Oh, this is the Reddit posts that show that they were anti juror number one and anti. There's a lot of anti plaintiff posts as well. Hope y'all have a nice holiday. How's everyone planning to spend that money we're getting paid by the defense to post on here? Dr. Quack Patrick has a sale. Buy 1K infusion, get propofol and dilaudid for free. Note to juror number one, bless your heart. Party at Daddy Shapiro's. Laugh emoji. I'll spend it all on creature comfort. LOL. Super chat so the YouTubers will notice me and think I'm clever. I think I'll buy some nice gold necklaces, purple attire, cheese whiz, hungry hippos. I'm jumping on the Jules bandwagon and having a borrowed K pie. Not really, but I'm thinking a really nice pool for hot water therapy. This is gross, you guys. They're just like, oh, and then they're posting pictures. So yeah, this is this is a prima facie case if I've ever seen one about, them also bashing juror number one after he's been outed. Oh, Melaine says, oh no, I went down that Reddit hole earlier. Most of those people are ridiculous. Hello, would you like to buy me a coffee? It's not really a coffee, it's just a donation on another website called Buy Me a Coffee. I like matcha latte, actually. Yeah, this is, are there any? All right, so here is a declaration from Greg Anderson. Is there anything like of utmost importance to read in here? I'm just going to scroll through this. Greg Anderson says he never had any conversations with juror number 1. He doesn't think anything that he did or did not do had an effect on his trial strategy. Talks about his typical practice and looking at all the jury notes. If anybody wants to read this themselves, you just need to go to the sarasotaclerk.com website and you just need to search up the case by its case name, Jack Kowalski, and then go to the one that's reopened on the left-hand column. So there's Greg Anderson's declaration. Here's a declaration from Jack Kowalski. Yeah, this is too much for us to go through all together. He says that his purpose in turning around, Jack says, was to make eye contact with Dr. Scott Richards, who is our expert psychiatrist, who I had found helpful in assessing the behavior of the jurors. So it's kind of like Bull. Do you remember the TV show Bull? That's what he did. He was a jury consultant. And he would watch the jurors and he would tell them who to pick, and he would tell them what kind of people they wanted on the jury and how they were going to decide. And then he would hire a whole mirror jury and have them watch the trial. But there are jury consultants out there and they're hired by both sides. That's the David Hughes stuff, Ethan Shapiro's stuff that we already read through. He says, "Hi, blank. That is so nice of you to reach out with your words of encouragement. It's especially meaningful coming from another attorney. I do check in on the Reddit threads on occasion. It serves as a great shadow jury." I was just talking about a shadow. I call it a mirror jury, but a shadow jury. A lot of the commenters pick up on ideas I miss in real time. Thanks for your contributions. I'm super jealous. You get to practice in NOLA. As for the jury, there's one outright hostile juror. I honestly hope he's a plant or knows the Kowalskis. I'm holding out hope for a hung jury. Okay. So that is, I don't know, proof, I think, that Shapiro knew that this was going on during the trial. And he probably should have brought it up earlier. Oh, and then he says, this is David Hughes, the help we've received from folks like you is amazing. Let's keep this quiet on the socials for now. I don't want the other side getting wind of all this help and then deleting a bunch of stuff. So thanks for saving it all. You're not alone. We are listening and compiling. Keep it up. It's like both sides slinging a whole bunch of mud at each other. Ethan says, I want to thank you and everyone else who's sleuthing this so carefully and meticulously. I've gone through the Reddit thread on juror number 1 with 1,000 comments. We read that one earlier, but there's the screenshot of it. CBD, this is the excerpt of post-verdict discussions. Okay, I think that's the, this is the little altercation that Hunter had with the judge about, judge, I don't think you're giving us a fair shake here. We read that. That's just the whole entire transcript of that. Boy, you know who made the most money during this trial? The court reporters. They get paid by the page. These transcripts are expensive. And yeah, when you get one, you have to give it to everybody, to give it to all sides on the court. So you have to order multiple copies. Transcript. Okay, Exhibit F. All right, declaration of Gabrielle Carlson. Let's see what Gabrielle has to say. She's this is under penalties of perjury. She is saying as follows. Oh, she's a law clerk with Anderson Glenn. She assisted the plaintiff's trial counsel throughout the trial. On November 9th, shortly after the verdict was read, I exited the courtroom before the court took a recess ahead of the punitive damages trial. My purpose in exiting was to begin printing those documents necessary for the punitive damages trial, and our printer was located on a small table just outside of the courtroom doors. I was sitting on a bench directly outside courtroom D's doorway with our legal team's legal assistant, Connie, facing the courtroom doors. Less than a minute less than 10 minutes after I relocated to the bench just outside the courtroom, I heard a loud noise, looked up, and saw the double doors of the courtroom swing open. Mr. Shapiro glanced at me while moving quickly out of the courtroom to his left down the hallway. As he exited the courtroom, he loudly exclaimed, "Effing ridiculous and effing S-bag family," and continued muttering other similar explicit phrases as he walked down the hallway with Ms. Lessing, the defense team's paralegal, behind him. He repeated these expletives and other similar phrases as he turned the corner to the room utilized by the defense team. Mr. Shapiro's comments were made in the hallway where members of the public and the media gathered throughout the trial. She swore to that. This is a declaration of Connie. And let's see if she's going to say the same thing. Yep, she's corroborating everything that Ms. Carlson just said. Okay, and these are this is a one-page transcript. This is the last page, and this is a transcript during voir dire. It is the conversation between the judge, juror number 1, who at that time was prospective juror number 1 because he had not been seated on the jury, and Mr. Anderson. Okay, so the court says, okay, is there anything about either that particular case or death by suicide that you hold any sort of strong opinions about death by suicide? And prospective juror number 1 says no. Judge says, okay, Mr. Anderson, do you have any? Mr. Anderson says, so in this case, if there were some testimony about one of the parties committing suicide, that your past experience is you could put whatever thoughts that came through your head at the time, set them aside, try the case based on the law and the facts. Juror number 1 says, yes, correct. Judge says, any other questions? Mr. Anderson says, that's all. Mr. Shapiro says, no questions, Your Honor. Ms. Cruels says, no questions. The court says, okay, sir, I'm going to have you go sit back. It's probably going to be an hour or so before we get back to you, but if you could just make yourself comfortable. Again, do not discuss this case amongst yourself. Do not do any. Juror number 1 says, correct, absolutely. Judge says, thank you very much. Juror number 1 says, have a good day, y'all. And that is a very extensive response to the motion made by the defense to get rid of juror number 1 for juror misconduct and to get a new trial and to have an interview of juror number 1 and his wife and to have juror number 1 and his wife turn over all of their electronics and all of their Google searches and all of their personal devices. What say you? Anna says, I need a gif of Judge Carroll when he gets frustrated with the IJ. Oh my goodness. Oh my goodness. All right, we went in a different direction tonight, guys, but I pivoted for you. Jeanette says, I speak military and the lingo isn't hostile. It's a way of life. Most New Yorkers I know speak very loud, but they're not angry. Yeah, I do speak loud. I know. That's why when I play videos, I have to sometimes whisper because the difference between the videos that I play and my own voice. And there's such a disparity there that people get upset. They're like, can you level out the volume? And I'm like, no, I don't have that expensive equipment. I don't have a soundboard. I'll just try and be quiet. Oh, thanks, Lynn, for gifting 10 memberships. That's amazing. I don't know who gets them. It's sort of like it's like a lottery. If you're in the chat and you're participating and you've opted into gifts, you can receive gifts. And so it's random. Hello, Grandma lives in the basement. Hi. Hello. Hello. Who knows what that's from? Hello. See if anybody can get that reference. See who the first one to get that one is. Thank you, Skoda. Thank you for listening. Without you guys, I wouldn't have a channel. So I thank you all so very much for being interested and for watching. Nope, not Home Alone. Hello. Nope, not Mrs. Doubtfire. Nope. It's a TV show. I'll give you a hint. Nope. Did they say that in Mrs. Duff? Thank you, Mujer Baraka. That is from Seinfeld. Hello. Unless they also said that in Mrs. Doubtfire. Now I'm going to have to go back and watch Mrs. Doubtfire. New York, Seinfeld's a very New York show. I think it's very New York humor. A lot of people don't like it, but I think it's hilarious, and I will watch it every single night, twice. Let's see, what do we have here? Hello, Paul Kalank. How are you? Nice to see you. Oh, good, Lita. I'm glad you enjoyed it. Thank you so much. I'll have no voice tomorrow, but tell me if you guys want to do that other motion tomorrow, because I've already prepared it, so it's ready to go. It's the motion for it's a new motion. No, I just pulled up the wrong thing. Hold on. It's the motion for remittitor, where they want all of the verdicts reduced and or a new trial and or directed verdicts and all of the reasoning therefore. And it's not as salty as this one, but there are a lot of good points of law that I think are important in this case. And you may not like what I have to say, but I'm going to always tell you the truth. Yes, please. Yes, please. Oh, yes. That is Newman, right? Is it Newman who says that? Peter, Seinfeld's the best. Newman. Hello. Okay, you guys want to do that tomorrow? I mean, I've already got it ready. So, I don't know what time I'll put it up tonight, but I'm thinking tomorrow, like, daytime. Somebody said to me, I think it was Sarah. Sarah, you said before the show even started, you said, Melanie, 4:00. Like, is that your prime time? Is that when you're the best? Yes, Brooklyn Peso. Larry David is genius. And I'll get back to that in a second. I'm going to leave it up there so I remember. Sarah Adams, hello. And it's whenever I'm done, like driving all my kids around. And I know that my kids don't have to go anywhere anymore. And I could sit here in my studio and just talk to you for however long I want. So my times of being able to do this shift with the day. So 7 p.m. is prime time on YouTube as far as I'm concerned. So I think I had a lot of competition tonight. So we didn't have a huge audience tonight at all. But listen, if you guys are here, I'll be here for it. So I will put it up tonight. Please set your notification bells to get all notifications so that we can talk about that motion tomorrow. That's more about the law than about the tea, if you know what I'm saying, and the gossip. Larry David is genius. If you have not watched Curb Your Enthusiasm, another one of those shows that I will watch 100 times every episode, and every single time I watch it, I will watch it again. I watched it on the airplane. There's an episode where Larry, somebody breaks into Larry's backyard and drowns in his pool, but he was trying to rob his house. And Larry's the one who gets in trouble because he doesn't have like a fence around his pool. It's hilarious. Hilarious. Paul, I see your comment. I'm not going to highlight it because I do not want you being the subject of any emotions ever. Yes. Curbed. Curb. Yeah. Great. I don't know what it's on. What streamer is it on? Is it on HBO? Is it on Max? I don't recall, but it is very. Jerry said hello. Dominique says, after Shapiro being such a jerk, does anyone still really listen to him? I don't know. Recovery addict. Hi, Jay Smith. Recovery addict called because he likes to recover items from the ground with the metal detector. Yeah, I saw some of those early videos too. But then somebody also said he was addicted to video games. But yeah, maybe he is addicted to the metal detector. And hey, listen, if you're finding engagement rings all the time, like who wouldn't be? Stephanie would listen to me read the dictionary. Oh my God. Somebody once said, I was talking about the rude comments before. Somebody once said, your voice is so hard to listen to. I feel sorry for your children. It's not hard to get some voice lessons, especially if you're going to be a journalist. Oh boy, did I pin that person to the top. Really? Turn the channel, dude. Turn the channel. All right, Scott, I don't care when the Islanders are playing because I'm a Ranger fan, okay? But I will make sure not to conflict with your Islanders game. But let's go Rangers. Hello, Ray. Good points are good points. I like learning about the law. I don't like how the defense presents facts, though. Yes, and I agree with you. Is the one the defense talks a lot about, but yeah, this is actually a very new motion. It was filed, I believe, also today. Oh, don't even kick me out of this, you Sarasota clerk. Thank you. I believe it was also filed, or this is the one. Wait, hang on. Okay, so this was filed on the 24th, which was Friday, but the court was closed. So although it's stamped and e-filed, I guess you can in New York you can e-file like electronically, but it didn't hit the court's docket and it didn't show up until into the court's computer until this morning. This is a trial for, a trial. It's a motion by the defense for a directed verdict, new trial, and remittitor. Basically, they're saying, we didn't do it, but if we did it, it wasn't that bad. And even if it was that bad, you should still overturn the jury's verdict because it's against the weight of the evidence. And there are some good points in there. And there are some things that you may not like, but that's what the law is. So we need to talk about legal duty. We need to talk about the ability of a trial court to reduce a verdict, to overturn a verdict. How judges don't really like to do that. How the defense has to make this motion in front of Judge Carroll before they're allowed to go to the appellate court in Florida. So it's a lot more technical, but it's interesting, I think. Thank you, reviewer. All my chats disappeared after I said you're flexible. I meant flexible after you asked if you were being boring. Is this your moderator or YouTube being the gatekeeper? I don't know. I don't think anybody. Thank you again for super chatting. But I don't think anybody deleted you. Not with your generosity. I don't think flexible. I don't think anybody would take flexible in a untoward way. So they're definitely on here. They're starred in my super chats. I can still see them all. See? Wait. Oh, another one. Wait, I was blocked when I said you're good at being flexible. You're good at being spontaneous and flexible mentally. You asked if you were boring as a veteran. That was a key to military success. No, they come into a separate folder in my StreamYard, but I still have them all right here. See? They did not disappear. YouTube, I think when you super chat something, it highlights it for a certain period of time and then it takes it down. But I am not a YouTube guru. All I know is where I can see them and they are totally still here. And I thank you. Thank you so much for your generosity. And you were not blocked or timed out or any of those things that nobody wants to be. So please don't be mad. I appreciate you and I thank you. Oh, it's ironic. Thank you for your super sticker. I appreciate you so much. Okay, yes. And Donna Marie, a reviewer is not blocked. Okay, thank you, Donna Marie, because Miss Donna Marie and the other moderators that are here tonight, like Scott or Black Rose, Scott says he hasn't even bounced anyone in 2 weeks because people know they can't come here and get bounced. Patroness Glow, you didn't kick anybody out tonight, right? No timeouts, no kicking outs. Lynn is here. She did not. YouTube might be glitchy tonight too. Yeah, I was having issues earlier as well. So, hello, Vids by Emily. Hello, hi. So no, you were definitely not blocked. Oh, nothing was blocked. And Cheryl is here. Thank you, Cheryl, for being a moderator. And also to Peter Pranzo and his wife, Rochella, who are amazing moderators as well. Thank you guys so much for keeping it classy and for policing the chat. And I love you so much. And I did not even get a chance to send my moderators a Thanksgiving thank you, I love you so much email, but I will. It's coming. And also to my little cupcakes, my members, thank you so much for joining Melanie's Little Cupcakes and for liking me enough to want to even be a member of my little club. Thank you to all my viewers, to all my subscribers. It's free. Just hit the notification, hit the subscribe button and the bell so you get notified of everything. You don't want to miss a thing. And also it's free to subscribe and it's free to watch and like and share the video. And it helps the algorithm somehow, apparently on YouTube. I don't really know how it works, but apparently if everyone is hitting the like and the subscribe and the thing and you watch it, and that's amazing. So thank you. Yes. Thank you, Lita. This is what I was going to say, Lita. Thank you so much for bringing this up. Oh, look at your profile picture. I have that same statue, I think, right here. See my little... You can't see it because your comment is blocking it, but wait. See? I have the statue right there. The scales of justice. And because it has actual arguable law, is even more reason why they could have left the insults out. Yes, they have legal basis for some of their arguments. Legal basis. It did not have to get nasty. It did not have to get personal. It did not have to dox a juror who was only doing his civic duty. And that was, in my opinion, in very poor form. Oh, I'm your first super chats. Thank you. Thank you so much. And you really went a little bit nuts on the button tonight, but thank you. Thank you for what you do. You do amazing work. The screenshots are real. There is a message up in the Reddit right now telling them not to message the lawyers too much. I have no doubt that all this stuff isn't real. But if they have good legal basis for having perhaps portions of the verdict reversed or reduced, for perhaps there are some of these causes of action that should have not gone to the jury based on the law. Perhaps there is some evidence that was let into the trial that should not have been under the law. Perhaps some of it was more prejudicial than probative. And perhaps there are some real legal arguments that they could stand up on. It didn't have to go so low, in my opinion. Didn't have to go so low. That's just my opinion. And that's it. Some of the emails were faked. Cult watcher. I don't doubt it. And that's why like I don't post stuff that's like I can't verify, and I can't source it properly. Hello, Lynn. It's sure you saw my commentator. I gave your email addresses to Gypsy Rose's stepmom, like we chatted about. Oh, that's amazing. I want to interview Gypsy Rose when she comes out on parole. She's coming out in December. And I love that show that we did for her, and we were so supportive of her getting out of jail, and I would love to talk to her. Thank you, Lynn. That would be freaking amazing. That would be amazing. All right, everyone, to who keeps the channel classy, thank you so much. I will see you tomorrow, and we will go through that other motion, that motion that may have some legal basis, in fact. So let's do that. I'll post it later tonight. Please set the bell to all notifications. Thank you so much for enjoying to spend your time with me, because your time is valuable, and I appreciate you. I appreciate you choosing to spend your time with me. But just remember, be cool, be kind, be classy. It's not hard. Thanks, you guys. I love you all. Peace, love, and I will see you tomorrow.